Okay.
Item number
Item number 2, Lordship.
this
It
is
will be
an
list after vacation, Lordship.
old pending case.
What is Lordship?
This is a very old pending case.
Yes, Lordship, but the thing is, he also not well, I am not else. It may be listed after vacation, Lordship.
Heard Mr. A.R. Agarwal, learned counsel for the respondent, who
Clement.
learned counsel for the respondent slash claimant, who prays for an adjournment on the ground of personal difficulty. He also submits that he had informed the learned counsel for the appellant regarding his prayer for adjournment, and who has raised no objection to the same. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after
Vacation, Lordship.
6 weeks.
Lordship.
May it please your lordship, with the consent of the other side, I beg to mention item number 7. My senior colleague Asbani, he is out of his lordship.
Heard Miss
F. Begum.
F.
Begum.
Begum, learned counsel for respondent number 2, who prays for an adjournment on the ground that her senior, who is the conducting counsel for the respondent, is out of station. She has also submitted that she has informed learned counsel for the petitioner, who has raised regarding her prayer for adjournment, who has raised no objection to the same.
Lordship may fix a date.
No fixed date. The prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
May I please your lordship? With the consent of the other side, I beg to mention item number 8. I am for the respondent manner, the matter may kindly pass over for the day.
What is your name?
R. Bora.
Eight question.
Heard, heard,
R. Bora.
heard Miss R. Bora.
Lordship, since it's a long pending matter, a fixed date may be given, short fixed date. Next week maybe, Lordship. Any day.
Heard Miss R. Bora, learned counsel for the appellant.
Lordship says she's for
I am for the respondent.
Learned counsel for the respondent, who prays for an adjournment on the ground of personal difficulty. Also heard Mr.
S.N. Ahmed, Lordship.
S.N. Ahmed, learned counsel for the
Appellant, Lordship.
appellant, who, while conceding to her prayer, submits that since this is a old pending case, a fixed date may be given. Stop. The prayer is allowed. Let this matter be listed again on, when do you want?
Any date, next week, Lordship.
On 19th of September.
Lordship.
Okay.
May it please your lordship. Lordship, I am mentioning on behalf of Mr. B. Devi that Mr. Learned Senior Counsel A.C. Sharma is out of station. Therefore, item 10 may be pass over for the day. Matter may be taken after the vacation, lordship.
You have informed the other side.
Lordship, I am for
Lordship,
the
consent has
respondent.
been taken, lordship.
Lordship, but on last occasion also they prayed for time. It's a 2019 matter. May I pray after 2 weeks maybe fixed, Lordship, and on 26 if it is convenient for this court.
Okay. Heard Mr. What is your name?
J. Borman, on behalf of Mr. B. Devi.
Heard Mr. J. Burman submitting on behalf of Mr. P. Devi, learned counsel for the appellant, who prays for an adjournment. Also heard Mr.
PP Waterpro.
P.P. Bhattakur, learned counsel for the respondent, who concedes to the prayer of the appellant. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after 2 weeks.
On
on
20,
it-
on 26 if possible, Lordship. 26th of September, it's a hearing there, Lordship.
Let this matter be listed again on 26th of September.
My lord. Obliged, Lord.
May I please your lordship? Lordship, this is a matter we are agreed from the order of the principal judge family court judge. my lords, without resorting to the fact that it is an order which is not a speaking order, my lords, I'd like to the petition which has been allowed by the Learned Family Code. My lord, it's at page number 132 of the petition, my lords.
132.
32. One is the, my lords.
Where is the impugn order?
Impugn order is at, my lord, page number 144. My lords, and the operative portion is on page number 147. My lord, it says nothing, my lord, it explains nothing why the additional evidence has been allowed. I can also hear in merits, my lords. Make a hearing on the merits.
Now, where is the impugn order? 144.
144. It starts at page number 144, my lords, and the operative portion is at 147.
Why are you aggrieved?
My lords, so basically what has happened there, my lords, if I may, it might take some leeway, my lord, to make the facts, my lords, to explain the facts. My lords, if my lords come to page number 132, my lords, for a moment, my lords.
Yes.
Right. He says in this application, that is petition number 122 of 2024, from which we are aggrieved for being allowed, my lord. He says that in the instant case, the petitioner has filed evidence on affidavit as PWs, where certain messages, etc., sent by opposite party respondent upon electronic device, mobiles under control of the petitioner were received, of which printouts were filed and exhibited by the petitioner collectively as Exhibit 4, but as required as under Section 65B of the Indian Evidence Act, 1872, to be filed and exhibited with electronic evidence mobiles, that is, he mentioned 4 numbers, my lords, which for the ends of justice and just proof and decision, it needs to be permitted by the Honorable Court to file and exhibit it being as matters at the evidence of PW's stage in the trial. Now, my lord, what happens, if I may have your attention, my lords. So basically what happens, my lords, that during this stems out from a cross-examination that we did in there's a parallel DV case also is going on between the petitioner and the respondent. And there were also certain WhatsApp messages that were annexed in this affidavit in DV case also. And during the cross-examination, we asked him whether he filed any certificate to the record or not. And thereafter, what he does, he admits that he has not admitted any 65B certificate or something like that. And secondly, my lord, these 4 mobile numbers have never been there in any averment or any pleading before any court. And similarly, filed a petition under 311 under the emails in before the Learned Chief Judicial Magistrate Kamrup Metro, and the Learned Chief Judicial Kamrup Metro dismisses application. However, my lord, the family court allows it. My lord, the DV case order, which the Honorable CJM, my lord, rejects the petition, is at page number, my lords, 129.
That is a different proceeding.
My lords?
That is a different proceeding.
Yes, my lord, this is a different proceeding. But however, my lords, when they try to bring out 4 mobile numbers, these were never in the petition, my lords. And if I try to bring my lord's attention to the kind of evidence he's trying to bring out, my lord, I'll just try to bring out this WhatsApp screenshot he's trying to bring, my lords. That is at page number, my lords, 48 to 51. My lord, if my lords has a look at page number 48, my lords, he's trying to bring this evidence on affidavit by filing a 65B. My lord, has page number 48, my lords. My lord, in page number 48, my lord, has it. So, my lord, this is a screenshot of a mobile phone. It is not a screenshot of a message, my lords.
No. Now, what is your grievance?
The grievance is that, my lords. Now,
You can cross-examine the
Yes, my lords. I'm
You
so
can-
grateful for what has fallen from my lords. Now, my lords, we can cross-examination on that. No worries about it, my lords. But the problem here is this, that my lord, he tells about 4 new mobile numbers, my lords, which are never there in his evidence. We have particularly pleaded before the family court that, my lord, these 4 mobile numbers have never been in the any above. My lord, the primary requirement of 65B is that in 65B4, in my humble understanding, my lord, there are 4 conditions precedent that how a 65B has to be exhibited. Now, my lords, he is trying to, here it is written Bernali wife. Now, my lord, someone sends a mobile, or someone sends a message to mobile, and then I take a screenshot of that mobile and try to exhibit that evidence, my lord. The problem is that it holds a bad precedence. Because, my lord, anytime we try to cross-examine him, he'll try to bring out such screenshots, and that will, my lord, prejudice myself in the whole trial, my lords.
At what stage this additional evidence was allowed?
But when we are trying to cross-examine the cross-examine
When still the stages of evidence of
evidence of affidavit.
first party.
Yes, my lord, they have been filed. Even the mother of the respondent also filed his, their evidence on affidavit, my lords.
When is the next date fixed?
Next date on 6, my lords. The 6 September, that is like after 2-3 days, my lords.
This is a divorce proof.
Yes, my lords.
You have filed it.
No, my lords. The respondents are filing.
The respondents.
Yes, my lord.
Heard Mr.
And Burman, my lords.
M. Burman, learned counsel for the petitioner. This application under section 115 of the Code of Civil Procedure, 1908. What is section 19?
Section 19 of the Family Code Act, my lord, however, material is only 115 and 227, my lords.
Impugning the filed by the petitioner, namely Srimati Bernali Pathak, impugning the order dated 19/7/2024, passed by learned Principal Judge, Family Court number 3, in which case?
FC Civil 1309 of
In FC Civil 1309
2021, my lords.
of 2021. Whereby the petition filed by the respondent, petition number 11122/24 filed by the respondent, praying for allowing the respondent to induce additional evidence on affidavit was allowed by the trial court. Issue notice to the respondent. You have annexed everything.
Yes, my lords.
Issue notice to the respondent. The petitioner shall take steps for issuance of notice to the respondent by registered post with ID within 7 days from the date of this order, returnable on 27th of September 2024.
Next dates of the proceeding till then, because my lords, the next date, my lords, is fixed for exhibiting additional evidence. Not till then, my lords.
Till returnable date, the operation of impugn order shall remain stayed.
I'm so obliged, my lords.
May it please your lordship. My lord, can you see the imping order by which my lord, my stock of the DW was closed, my lord. Actually, can you see the imping order is 15. Two order, my lord.
Page 14.
Yes, lord. May I read, my lord? That's got it. On 19/7/2024, my lord. By this order,
You are defendant,
is entitled to I am the defendant, my lord. I have already filed my evidence in chief, my lord.
but on many occasions you have failed. On how many occasions you have
Lordship
failed?
may kindly see, it is not only my fault, my lord, but I have annexed all those order. Lordship will find this order. Lordship may kindly see page 48 onwards. Sometimes, my lord, you was absent, my lord. And I have taken, but in every time, my lord, I have filed petition showing the reason. I have taken time.
How many times?
Lordship, 18/3, my lord, PO was absent, my lord. Next 17/3, 17/11/2023 also PO only, my lord. 9/1/2024, my lord, I have taken time, my lord. Next, my lord, 17/11, that is 7/3/2024, my lord, PO was only. And 22/4/2024, my lord, I was absent, my lord. Next, my lord, will find 3/5/2024. I have paid for time, my lord. That 11/6/2024, PO was only. So, my lord, though I have taken 3-4 times, my lord, but I have submitted petition only one date, my lord, I will report, my lord. To show you. But by the impugn order, my lord, first order, my cross of DW1 was closed, and thereafter I filed.
1711,
Lordship.
after 1711,
After 17/11, my lord,
19-1,
19/1,
you took leave,
9/1.
9-1. Thereafter,
Thereafter, my lord, will find page 51, 7/3. PO was on leave. Then 22/4/2024,
no, 7-3,
page 51. And thereafter, my case was 6/1/22/4/2024. That day, my lord, the defendant side is absent. And thereafter, my lord,
no, you tell me fairly, how many times you have taken adjournment?
my lord, let me count my lord. Round. My lord. 2.
When is the next date fixed?
My lord, on 5/9, my lord, next day. My lord, for the end of justice, my lord, one chance may be given, my lord, because my lord, 19/7. Oh, yes.
How many, on how many dates you have lapsed?
My lord, I have count, my lord.
You have forgot,
Yes.
it is even difficult to count on so many days you have taken
My
adjournment.
lord, from whatever, my lord, finding is the learned, my lord, the code below is 18/9/2023. I have annexed those order, my lord.
Because
And
if I issue notice, it will again delay the
delay the process, my lord.
proceeding. Therefore, you have to pay cost. You pay cost.
My lord, I will be ready, my
That,
lord.
how much cost will you pay?
My lord,
That is dependent on how many times you have taken adjournment. Therefore, I was querying you, but You are unable to even count number of,
5,000.
no. Third, Mr. G. Uddin, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioners number 1, 2, 3, 4, 5, and 6, impugning the order dated 19/7/2024 passed by learned Civil Judge Junior Division number 2, Karimganj, in title suit number 129/2012, whereby the learned Civil Judge Senior Division, learned Civil Judge Junior Division number 2, Karimganj, rejected the prayer of the petitioner for bringing
Cross-examination of DW1.
for
And next subsequent order, my lord,
prayer of the petitioner praying for adjournment for examination of DW1. Stop. Learned counsel for the petitioner has submitted that. Why you failed?
my lord, one is shown personal difficulty and another date, my lord, two impugn order, my lord. Lordship may kindly
No,
next
in-
week 15.
No, in this revision petition, what
But-
ground you have taken?
Due to his, my lord, son's admission. In both the petition, one petition filed for personal difficulties, my lord, and another petition on
Learned counsel for the petitioner has submitted that on the said date, that is on 19/7/2024, the petitioner could not produce his witness, that is DW1, for cross-examination due to some personal difficulties which he had narrated in detail in his petition, which was registered as petition number 227/08. Stop. Yes. What suit is
well, suit is for, my lord, right title interest
over
for, my lord, 50% of the share
of,
of the land.
in whose possession the land is presently?
Land is, my lord. Land to pension. Land corporation. My lord, possession I have not clear, my lord, but I have annexed the title suit, my lord. Lordship will find page 16, my lord.
Stop. Stop. On perusal of the revision petition and documents annexed therewith, it appears that the petitioner has taken adjournments on several dates for producing his witness, that is DW1, for cross-examination. And he was given indulgence on several occasions. However, he failed to produce his witness, that is DW1, for cross-examination. And the stop. Learned counsel for the petitioner has also submitted that the case is now the title suit number 129/2012 is now fixed for argument on 5/9/2024.
Yes, sir.
and he would be greatly prejudiced if he is not allowed to adduce his evidence in his defense. Stop. Though on perusal of record, it appears that, no, before that, as the petitioners are the defendants in the title suit number 129/2012, and as the case, the said case is near its culmination, this court, considering the nature of grievance raised by the petitioner in this revision petition, is of considered opinion that if notice is issued to the respondents, it would cause further delay in the trial, and therefore it proposes to dispose of this revision petition by dispensing with the notice to the respondents. Stop. Though it appears that the petitioners were given sufficient indulgence by the trial court for producing their witnesses. However, they have repeatedly failed on several occasions. And though the prima facie, there appears to be no irregularity in the impugned order which has been put to challenge in this revision petition. Stop. Comma. However, considering the fact that the suit, the aforesaid suit is for declaration of right, title and interest, where the and any decision in the said case would also affect the rights of the present petitioners who are the defendants in the said title suit. Hence, for the ends of justice, this court is of the considered opinion, they should be afforded at least one more chance to produce their witness, that is defend DW1 for cross-examination.
Well, and other DWs also, my lord, because
Other DWs, there is
Yes, my lord.
no prayer.
19/7/2024 was fixed for further DWs. And thereafter, my lord, next, my lord, page 15, 26/7/2024, we submit an application, my lord.
You have to produce them on a single day.
My lord, may not be possible, my lord.
Then
Next up.
I am rejecting this.
All right, my lord. I will do that. My lord.
DW. DW1. DW1 before the trial court. The loss suffered by the plaintiffs loss suffered by the plaintiffs due to the delay caused by the present petitioners in producing DW1 for cross-examination may be compensated by imposing adequate cost. Stop. This court therefore allows the petitioners to produce DW1 for cross-examination before the trial court on the next date fixed, that is on 5/9/2024, subject to payment of rupees 10,000.
10,000, my lord.
10,000, which shall be paid to the which shall be the precedent which
Like-
shall be the condition precedent before examining, cross-examination of DW2. Stop. The cost, if paid, shall be given to the respondents by the trial court. Stop. On the failure of the payment of costs by the petitioners, the trial court may proceed with the trial in its regular course. With above observation, this revision petition is hereby disposed of.
My lord, DW one cross is there, my lord, further,
Further, you may make prayer before that court.
no, my lord, that petition was rejected, man. Lakshmi, kindly see 26/7/2024. That's all.
No, the impugn order does not mention anything about that. Impugn order mention only about DW1.
No, I have, my lord, impugn two order, my lord, 19/7/2024 and 26/7/2024. Next page, ma'am. 15, page 15 last, may kindly see, my lord. Parties are represented, today is
Sir.
fixed for DWs. By petition number so and so
Eta
defendant,
paragraph aru dibe, eta paragraph aru dibe. As regards prayer for educing further evidence, it shall be considered by the trial court on the next date fixed if the petitioner produces DW1 for cross-examination.
oblige.
None has appeared for appellant on call. Let this matter be listed again on 10th of September 2024.
May I please your lordship?
Yes.
May I please, my lord? I have filed the CRP, my lord. The impugn order been challenged. Order dated, my lord, 4/8/23, my lord. That is annexure 12, page 62, my lord. Here, the lordship got it, my lord.
Just a page.
Page 62, my lord. Annexure 10.
Yes.
Your lordship got it, my lord. This order was passed in regard of the condemnation mallet petition filed by them, the opposite party, who is a plaintiff in the title suit. I am the defendant in the title suit. And this order was passed on 4/8/23. May I read the order, my
No,
lord?
What it says?
My lord, it
Yes.
says that the accepting of the condonation is perverse, illegal, and not in accordance with the law, my lord. Condonation.
No, I have not understood. This miscase was filed for what purpose?
This miscase was filed, my lord. Then, my lord, you may I take your lordship to page 50, my lord.
No, you
Annexure D.
answer my queries.
My lord.
Why this miscase was filed?
This for condoning delay, my lord.
In preferring
In misappeal, my lord.
misappeal.
My lord.
Okay. Misappeal against which order?
Against the injunction order, my lord.
Granted in favor of?
In favor of the defendant, my lord. Where
Okay.
it was been granted as absolutely. After hearing both the parties in length,
No, granted in favor of defendant.
granted in favor of defendant.
You filed an injunction petition.
Yes,
before
my
the-
lord.
Okay. Why the suit was filed?
For right title interest cause possession over the disputed.
By the respondent.
We have got the counterclaim. They have filed here the plaintiff. I am the defendant.
You also filed a counter.
I have filed the counterclaim.
Okay.
And
There you filed a miscase for
Yes.
seeking temporary injunction.
yes,
They filed.
Injunction was granted to you.
yes, after
They-
hearing,
They
both-
preferred an appeal
yes, my
and misappeal,
miss appeal,
which was,
dismiss.
no, it was delayed appeal.
Yeah,
De- So they filed a condonation of delay application,
yes.
and that delay application was allowed or dismissed.
My lord, that
Allowed.
that condemnation of delay, my lord,
Was
no, my lord,
delay was condoned or not?
that was delay was allowed, my lord.
Okay.
Allowing this delay, my lord, I have preferred the CRP
Against that,
against that condemnation petition.
okay, okay.
Before that condemnation petition, which was been filed, that is also have a record, my lord, the record of the High Court, my lord, because they have not challenged the earlier that absolute injunction order heard by both parties. They have come before the Honorable Court challenging the ad interim order of the injunction before the Honorable High Court. So, my lord, may I take your lordship to the CRP, my lord? On page, my lord. What is it? No, CRP. too. Huh? 48, my lord, he says 48. Wait, lagi gis. This is the order, my lord, 48. Page 48, my lord.
This is which order, which you are impugning?
Yes, my
No.
lord. Before this order, he has come earlier in 256 CRP IO, my lord.
What is 48?
Page 48, my lord.
Yes, what is this?
My lord, challenging the ex interim order, my lord,
By whom?
by them, my lord.
Okay. That,
And
let me understand.
my lord.
In the miss case, before granting you injunction, an ad interim injunction was also granted in your favor,
Yes, my lord.
which he challenged before the High Court by
High
filing a CRP.
By this CRP, my lord.
What happened in that?
Yes,
That
my
was
lord.
dismissed.
Dismissed.
Then,
Dismiss. And the last part, 49, page 49. Wait, your lordship got it, my lord, page 49.
yes,
My lord, one observation was made after dismiss of this suit. Then, my lord, I have to take your lordship. From page
What?
48 down part, my lord. Page 48 down part, the interim order, my lord. May I read it, my lord?
yes,
The order dated 1/7/20 was put to challenge in mid-J appeal case number 221. Such appeal was dismissed by the learned appellate court under its order dated 30/6/22 for the reason that the ad interim injunction was made absolute, next page, by order dated 13/8/20. And also for the reasons that there is no unreasonable in passing of the order dated 1/7/20. After absolute. Thus, the order dated 1/7/20 passed by the learned trial court below, which was under challenge in the mid-J appeal 221, merged with the final order dated 13/8/20. Therefore, there is no scope for this court to entertain a challenge to the order dated 30/6/20 in the present revision petition or the order dated 1/7/20 or order dated 19/3/20. At the cost of repetition, it is observed that all the aforesaid order dated 19/3/20, 1/7/20 merge with order dated 13/8/20, whereby temporary injunction was granted till disposal of the suit. Petitioner can still challenge. Here is the point. The petitioner can still challenge subject to provision of prescribed period of limitation, satisfactory explanation, the order dated 13/8/20 before the appellate court under order 43, rule 1R of the CPC 1908 and not before this court under article 227 of the Constitution of India. Accordingly, in view of the aforesaid finding, this revision petition stands closed, not being maintainable. However, petitioners shall be at liberty to approach the appellate court under order 43, rule 1R of the CPC, assailing the order 13/8/20 subject to the prescribed period of the limitation. After this observation, he files a condemnation petition, putting the challenge, the absolute injunction order dated 13/8/20, where the appellate court under Ms. J case 23, the annexure 10 comes into effect, where condemnation was allowed. How the condemnation was allowed, then, which has to be according to the prescribed period of limitation, where the absolute injunction order was passed on 13/8/20, which was being put to challenge in the year 23, my lord. That order, which allowing such order, is perverse, illegal, not in accordance with the law. Therefore, this revision, under this revision, the challenge was stayed. This order was stayed. So he has come to vacate, modified of this order. And may I take a lordship to his application?
No, what was stayed? What was stayed?
Delay condemnation, my lord. What was delay? There was a delay.
CRP.
Yes, my lord. Delay was not CRP actually, my lord. Lower court below condoned the delay and my lord revived.
No, against that.
Yes, yes, my lord. Against the order, my lord, they have filed this.
The appellate court, first appellate court,
Yes, my lord.
where the appeal was filed,
Yes,
condoned the delay.
Condoned the delay.
Against that delay condemnation application, they
Yes.
have approached this
They
court.
have approached this. people.
Now, whether in this CRP,
Yes, my lord.
any stay was granted?
Yes, my lord. Or interim order has been passed, my lord.
Okay, okay.
That
Now-
is why, my lord, I have filed vacating this stay order. Here, my lord, what is happened, my lord?
No. Let him come.
Yes,
Yes, we are disposing of the
yes.
Now, may I take a lordship?
main CRP today.
Yes.
Yes.
Now, may I take a lordship, my lord? This order 4823 is challenged before this honorable court in CRP 1824, my lord, civil revision petition, my lord. Here, the honorable appellate court, first appellate court, where it says the second paragraph, my lord.
Yes.
It is a plea of the plaintiff petitioner that he could not prefer the appeal in time, as the question whether the instant facts is related to revision or related to appeal was not known to him, because the impugned order dated 13/8/20, in respect of which the present petition has been filed, was passed in the main suit without registering a miss case. It is the further plea of the petitioner plaintiff. The Honorable Guwahati High Court High Order dated 24/3/23 passed in revision CRPIO 256/22 made it clear that the petitioner plaintiff is at liberty to approach the appellate court under section 43 rule 1R of the CRPC, selling the order dated 13/8/20 subject to prescribe of limitation. In the light of the order passed by the Honorable Guwahati High Court, the petitioner has preferred the instant appeal before this court and filed a petition for condonation of delay by stating that because of the restriction imposed to the corona pandemic for entering in the court premises in the later part of 22. There is no pandemic at the later part of 22, my lord. The petitioner failed to file the appeal on time. Heard, next page, my lord, heard the other side regarding condonation of delay. According to section 5 of the Limitation Act, section 3, an appeal or application may be accepted even after limitation period for the same is over. If the appellate applicant assures the court that he had a sufficient cause for not being able to file the appeal application during the limitation period, in other words, the court may accept an appeal or application when filed after the limitation period if the appellant or the applicant show that he has a sufficient cause for not filing the appeal or application within the prescribed period. In the instant matter, the petitioner states that there has been a delay of 99 days when the order itself challenging 13/8/20 challenge in the year 23, how the Honorable First Appellate Court presume or presumption to draw of 99 days delay.
How many delay?
It is
Days
total
delay. 1058 days, my lord. 1058 days since passing of the order dated 13/8/20. May I continue, my lord? Yes.
In filing the appeal, on the other hand, opposite party contention is that the period of filing appeal is only 30 days and the petitioner has exceeded the period of indiscriminately at and for relatively long period. Moreover, the delay cited by the petitioner cannot be termed a sufficient cause. After a close analysis of rival contention and taking regard to section 5 of the Limitation Act, it suffices that the word sufficient cause has to be interpreted taking regard to the facts and circumstances of the case. It is observed that from the intending facts and circumstances, the petitioner plaintiff had every reason to doubt the maintainability and that further he was again debarred by the COVID pandemic protocol. As the Honorable Supreme Court stated in MS so-and-so represented by partner so-and-so, in case now so-and-so, that the need to explain every day's delay is no longer necessary. Only in that case, in the pandemic period, not after the pandemic period. Here he has challenged the order dated 13/8/20. And already he has approached the Honorable Court, High Court, in 256. May I read it, my lord? Father, the length of delay is not the criteria, but the correctness of the reasons or the explanation for delay is the important factor. As per the settled law on this subject, sufficient cause has to be liberally interpreted provided negligence, inaction, lack of bona fide, etc. are not made out. The purpose of the court are established to render justice. There is no hard and fast rule for condoning the delay, and each case should be dealt with its own merit. Last part. Hence, after considering facts and in the letter and spirit of decision made by Honorable Supreme Court, above, I am inclined to allow the petition 40/24/423 with a cost of 2,000. This is the order, my lord. So the first appellate court has taken the presumption of pandemic period in the year 23, passing of the order, since the plaintiff petitioner had already came before the Honorable Court in IO 256 interim order, page 48. Knowing the facts that 13/8/20 absolute injunction was heard by both the parties at length by the Munshi Bajali. After that, he has challenged, without challenging the absolute order, he has challenged the interim order before the honorable
no.
court.
Please don't repeat because these facts you have already stated.
Yes, ma'am.
Don't go into facts now. Now make your submissions.
That's right. Now comes my lord. Then I will have to take your lordship to the page 50, his petition which he has filed under section 5 of the Limitation Act. Page 50, my lord. Here in this petition, my lord, nowhere this petition can be said to be under provision of section 5 of the Limitation Act, where he had never stated the period condoning of delay from such and such to such period. Number one. Number two, this petition does not made out under section 5 of the Limitation Act as maintainable by the three conditions which is clearly made out under Limitation Act of section 5. What is that? The three conditions are that sufficient cause that has to be shown. What are the sufficient cause that is not been there in his petition? Secondly, my lord, this condonation of delay has to be shown that he has been prevented. That is also not been mentioned. And day-to-day explanation is also not been mentioned in his petition, my lord. So, without mentioning the delay of time periods, the taking into consideration by the appellate court, where it has been clearly made out of 99 days, which is not been stated in the petition, how can the presumption can be taken by the appellate court? That is my fact, man. Secondly, my lord, to make out a case, the prescribed period, which he has come earlier before the honorable court, the prescribed period does not mean beyond the period of the limitation. Prescribed period means within the ambit of the prescribed period. And gross negligence, sufficient cause has not been stated by him in his petition. Sufficient cause, negligence in the routine manner. So, considering his petition by the trial first appellate court and passing of the order 4/8/23, without taking into consideration the length of period of his delay, is illegal, my lord. But day-to-day explanation has to be made.
Yes, Mr.
That is the fact.
Mr. Das.
In this title suit,
How much delay was there?
yes, my lord. Here it is mentioned what is happened actually initially my lord, this injunction order was passed by their application, my lord. It was initially passed, my lord, that order was passed on 19/3, my lord. They have annexed here. It was ex parte order. First interim order is, my lord. And that is page 27 entitled suit 19/3/2020, my lord. 19/3/2020. In my case, my lord, they have filed this, my lord. And I am placing, my lord, they have filed more than 12 petition, my lord. Rejection of the WAS, my lord, counter claim,
No,
thereafter
you come to-
punishment.
Come directly to
Yes,
the.
my lord, directly, just 19/3, this ex parte order was passed, my lord, during the lockdown time. And my lord, I have filed, my lord, objection, IA, my lord, that was, my lord, under section 151, annexure, my lord, 5, page 34, against the said order, my lord. That injunction order could not be, my lord, we did not have any information because that I could not be able to appear before the honorable court on proper time due to operation of my mother when appearing lately, the security personnel in the court premises restricted me to enter inside the premises. That in the above situation, I could not be able to take proper steps, and my engaged advocate also informed me that no adverse order will be taken by the honorable court. Lockdown period, that in the against the said injunction order 19-3, my lord, 2020, at the peak of the lockdown time, my lord. And this application, my lord, was filed, my lord. It was 23-2020. It is therefore prayed that your honor will be pleased to vacate the interim order dated 19-3-2020 after call for the record and give me the chance to plead for the avertment made by the defendant. We objected in this way. Thereafter, my lord, what is happened next page, my learned friend also, next, my lord, Annexure 14, page 66. Annexure 14, page 66. This application, my lord, for vacating the ex parte injunction order, we filed, and that was considered. Here it is mentioned, plaintiff present along with
Page 66, there is
page
no,
66.
no 66.
Page 66, Annexure 6. Annexure 14, sorry, Annexure 14,
No, there is no 66 number
or
page.
38, it will be 38. Page below, there's the number here.
Court
Hmm?
66 party nine.
Not 38, it will be 38, my lord, 38. Two numbers should be,
Court hai bolo.
172020 order, my lord.
What is this?
Here, my lord, application for vacating the ex parte interim order was considered in this way.
No, Mr. Das, you
Yes, sir.
come to the point. He is challenging the the delay condoning order.
Yes, my lord.
So why his petition should not be allowed? He has stated that you have not mentioned in your condonation application the numbers of days for which delay has to be condoned.
Yes, my lord.
Still, the appellate court calculated it to be 99 days.
99 days.
On what basis it was
Yes,
calculated?
my lord.
He's saying that delay is of 1058
58
days.
days.
What is your counter submission to that?
Yes, my submission.
Then he also submits that you have not mentioned in your applications sufficient cause which prevented you to come to the court within prescribed time.
Yes,
You make your counter submission.
yes. my lord.
Other things we are not going into in
Yes,
this CRP.
Here, my lord, as we challenge the order of the, my lord, learned court below, my lord, because 172020 it was challenged against the order of the 172020, a continuation of the ex parte injunction order we challenged there. In the meantime, my lord, that order was passed 13-8-2020. 13-8 absolute injunction order was passed, my lord, in the learned court below. That's why, my lord, we have challenged the said orders, my lord, before this honorable court, and CRP, it has been mentioned that in the CRP, this honorable court pass order, staying mentioning here in that page 49, possibly that is dear mention at the cost of the repetition, it observed that all the aforesaid orders dated 19-3-2020 ex parte interim order, continuation of
No,
17.
that he has already submitted. I have
Yes, my lord.
understood. You
That's
did-
why, my lord, as he has counted the period, my lord, from the date of the order passed by this honorable court, with effect from the 24-3-23. And
24?
19-3-2020, my
No,
lord.
no, from which date the competition has to be made? From the date of passing impugn order? Or from the date of passing order by this court?
Here, I mentioned erroneously passed order 19-3-13-8-2020. That it is mentioned. Page 50, my lord. That the suit land is on land of the appellant so the original pattadar so the defendants are mere trespasser, but overlooking all those facts, Lanet Munshi Bozali erroneously passed orders 19-3-2020 and 13-8-2020, directing both the parties to maintain status quo, that causing a great injustice to the plaintiff appellant. That the order passed in 13-8-2020, the plaintiff appellant filed petition for certified copy on 1-9-22 and have records. The copy got ready on 16-9-22 and same was received on 16-9-22. So, period will be possibly from the 16/9/1922. But due to the COVID-19.
No, you answer my query.
Yes,
The impugned order was passed on 13/8/2020.
yes, my lord.
Why you prayed for certified copy on 1/9/2022 after 2 years? What is the explanation
Yes,
in-
my lord.
for that gap? From 38/20/2020,
Hmm.
you had period for 30 days to prepare an appeal.
Appeal, my lord.
That is within 13/9, you should have preferred an appeal. No,
But-
but you have applied for a certified copy after 2 years.
2 years, my lord. That is.
What is the explanation for that?
My lord, here, my lord, their impugned order, what was passed, my lord, in the Lord Lanet Court below, that was passed 36, my lord, 20, my lord. We have challenged the order, Miss J order, that was 36/22. 36/22. Early, kindly peruse your lordship, page 80, that is, page, my lord. Miss appeal, that was disposed of 36/22.
Which page?
Page, my lord, 80, to Annexa 20, my lord, page 85.
There is no 85 number page.
Page below, where is the DSCB?
Oh, yes.
Yes,
Sir,
sir.
I am adjourning this matter.
47, my lord.
Both of you are not ready.
I'm ready,
You are-
my lord.
Ready, my lord.
Not at all.
I'm ready, my lord. I'm sorry, he's not
Number-
submission correctly, my lord. They're making confusion, your lordship, my lord. He should explain as per your lordship query, my lord, to the point to point.
Mr. Das,
That's it.
my query is, when the impugned order was passed on 13/8/2020,
My-
Yes,
you applied for certified copy in the year 2022.
yes, my lord.
What is the explanation which you have given for this gap?
In
Because-
his limitation petition, my lord.
But there is a, my lord, 36/22, my lord, that order has been passed, and during this period, there is a
Which
judgment.
order?
Honorable Supreme Court, there is a Supreme Court judgment, my lord.
No, that the period of delay was
Yes,
condoned by the apex court's order.
yes, my lord.
Where is that statement? Suppose that statement is not there.
Yes, my lord.
So till
I-
we,
I have mentioned here, my lord. And this impugned order was passed, my lord, 36/22.
which order?
This order, my lord, 47, my lord, page. Because what has been served by them, these
Then
are not clear.
You just answer my query. You are not impugning this for this order. 36, where is that 36/20
Yes,
order?
22 order.
Where is that order?
That order, my lord, the copy served upon me, this page shows that 85. What has been served upon me, my
You
lord?
serve a correct copy.
That's
Yes,
correct
my
copy, my lord. I'm
No,
serving
no.
correct copy, my lord. It is correct, 42, my lord. I
Then
said
it is
42.
not here, my lord. What is served
42,
upon
sir,
me?
it is written, my lord. Sir, my lord. My lord, as your lordship query.
And this is the copy, my lord.
Properly, my lord.
These are the copy, my lord, served upon me, my lord. Can you please read it?
Heard Mr. K.D. Chetri, learned counsel for the petitioner. Also heard Mr.
Das,
H.
Dek- H.K. Das.
H. Das, my lord.
Learned counsel for the respondent. Let this case be listed again on. You come prepared.
Yes, my lord.
I have not gone through the matter. You must be able to make me understand. Let this case be listed again on 10th of September, next week,
10 of September.
as part heard matter.
Yes, my lord.
Clearly, but he should explain properly,
On
my
10,
lord.
on 10,
On 10. Your lordship has already made 3 queries, my lord.
next.
Forty-seven years. Bible says very good. Yes.
Your lordship. The application, your lordship, is a commercial quantity. Here, your lordship, the petitioner has been behind bar nearly 1 year. The
How many What is the time?
Nearly 1 year, it's not completed 1 year. But my case is not on long incarceration, it's basically on the part that there were 14 witnesses. Out of the 14, as per my instructions as yesterday, 8 witnesses have already been, evidence has been taken. Now I have checked the scan copy as well as the updated status report is not there. Since I am relying on the ground that the guilt of the petitioner cannot be established under the on the basis of all these evidences. Therefore, I think that would be one of the requirement. As such, your lordship may call for the scan copy as well as the updated status report.
No, otherwise also on that ground can bail be granted.
Yes, yes, I have decisions, I'll just produce that.
That in the midst of the trial, if
Yes.
some of the
There are
witnesses
even
have,
a very recent decision, I think this is by the Supreme Court in the case of Prem Prakash, that came up on 29th of August.
what has been, what has,
That court has gone through the evidences and found that it does not implicate the petitioner, and then it said, no, they
But
can
say-
bail, it was a bail matter.
no. My query is, suppose there are 14 witnesses. Only 8 have been examined.
Yes,
Only 8, some witnesses are yet to be
Yet to
examined.
be
They
examined,
may
but-
implicate you.
but why I'm coming to that, because the question is, that these are the witnesses. 4 of the witnesses, basically, she's a witness, independent witness, and some other witnesses. That does not at all implicate. Once your lordship, except the police witnesses, rest of the witnesses, I think, have been taken, except one, I think one shop owner, he is not there. Other than that, all the witnesses, not a single implication. And second point that will be raised, would be taken up is with regard to he was not arrested. He was not even named in the FI. It was on the basis of the, your lordship, co-accused statement that he has been arrested subsequently. Not arrested, he is a sworn arrest in this case. In another case, he was behind the bar. So that is basically on this matter. So therefore, I was basically harping on the fact that we will have to go through the evidences on record to show whether there is any implication against it.
Now, on what ground you have filed this application?
Basically on these two grounds. Number one is that he's arrested on the basis of the statement of the co-accused. And the second is there is no evidence against the petitioner with regard to the implication with regard to this matter. And your lordship, nothing has been recovered for him. He was arrested much later. Sworn arrested much later.
So with,
Lordship can fix any day with scan copy, or I can also file bringing on record the
Yes.
4 evidences I have brought on record,
Mr.
but
Bush,
the rest are not there.
My lord, what I have found, definitely that the later part, what my learned senior colleague has submitted, that is not available, my lord, the report. But here, lordship, the matter relates to a person who has monetary transaction with the main accused, and that is a part of the record, and there is sufficient transactions are available. And not only the part of the statement of the co-accused, it is the statement, there is a statement of the wife of the present accused petitioner. She also stated that he is a habitual offender, earlier arrested in a different case of Gitanagar police station regarding the same issue, similar issue.
That evidence is PW8, your lordship, which is not there. PW8, the wife has been, is a witness here. She did not say anything.
But there are material.
I have the copy, but
there are
since it
transactions.
is only a photocopy, I'm
Use
not
transaction.
relying on it. I have the copy of all the evidences.
okay.
And with regard to the transaction, money transaction part, there has to be a linkage. Just because I'm having a transaction with him, with whatever, that cannot be a ground. It can be crores of money or 1,000 rupees is not the factor. It is a factor that has to be a linkage with the, your lordship, narcotics dealing. That is also there by a Supreme Court. All these judgments I will bring it if required.
Okay,
I have gone through these judgments. I
okay.
have not brought it today, but
Heard Mr. Y.S. Mannan, learned counsel for the petitioner, also heard Mr. K. Bush, learned additional public prosecutor. Learned counsel for the petitioner has submitted that till date, out of 14 listed prosecution witnesses, 8 have already been examined
Yes.
by the trial court. And none of the examined witnesses have implicated or stated anything against the present petitioner. And he submits that this in itself may be a ground for allowing the petitioner to go on bail. He therefore submits, the learned counsel for the petitioner also submits that as the evidence of witnesses who have already been examined is not on record, same may be required to be examined by this court. The learned additional public prosecutor also submits that the up-to-date the evidence, the copy of evidence of the witnesses who have already been examined may be required to looked into. Therefore, let the scanned copy of the evidence of all witnesses which have been recorded by the trial court be called for registry to issue requisitions. Let this case be listed again on when we should we fix.
Any that.
I will not be there between 16 and 20th, any day prior or after. I don't have any.
On 24. On 21st September 2020.
Much obliged.
Well, in this case, my lord, page 46, as earlier ordered by your lordship. Now, the order dated 13/5/2024, my lord. Your lordship direction to complete the witnesses within 6 witnesses within 3 months. And today, my lord, 3 months have been elapsed. And on 14/8/2024, my lord, your lordship directed what is the status report. And report is received, my lord. And no witness examined till date.
How far, how long you are behind the bar?
I'm, my lord, today 1 year, 6 months, 6 days.
How many, when were you arrested?
I'm arrested on, my lord, 27/2/2023.
What was the contraband received? Contraband recovered?
161 gram, my lord.
161 gram of heroin,
No, my lord, Yaba tablets.
methamphetamine.
Yes.
When the charge sheet was laid,
Charge sheet, my lord, charge sheet, yes, filed on 16/8/2023.
how many accused were there apart from this?
Sole accused, my lord.
Okay.
I am the
When the charges were framed,
charges, my lord,
Charges framed 4/12/2023, madam.
how many listed witnesses were there?
6 witnesses, my lord.
How many?
6,
6. How many have been examined?
nothing, my lord, no one examined.
Yes.
My lord, earlier occasion, my lord, heard at length the matter and called for the status report, my lord. The earlier when my lord was pleased to reject the petition that is on 13/5/2024, my lord. On 13/5, after 13/5/2024, my lord, there's two dates were there. One is 12/6/2024 and another one is 18/7/2024. And 12/6/2024, my lord, that is learned trial court issued the bailable warrant of against the PWs, madam. And on 18/7/2024, though the PWs were present, but they could not be examined. And next date for the evidence was fixed on 17/9/2024, my lord. So, my lord, my humble submission before your lordship is that there is no they have taken all the measures to make the attendance of the PWs in this case, my lord. And the trial commenced, my lord, on the, from the, that is the charges stream on 4/12/2023, my lord.
On 18/7, my lord, both the
That is, my
PWs
lord,
were
from the
present.
January, we may take that
Present.
from the January itself, that is the evidence part started, my lord.
And the family see, they are present, my lord, on 18/7, two were present.
3/2/20. From February 3/2/2024, my lord. That is the first date, I think. For evidence.
What is to be done? Should we wait for 17/9?
My lord, kindly see, my lord, order dated 22/4/2024. On 12/6/2024, it was fixed evidence. On 12/6 past, my lord.
Now,
12/6,
which order you,
the page number 55, my lord.
in your bail application?
Yes, ma'am. Before that, my lord, page number 52, 17/2/2024. There is no fixed for evidence. Thereafter, case
No,
is
no. That part I have understood.
We
The
come after
submission is
13/5/2024,
that next date is fixed on 17/9.
17/9, my lord.
and
How
my
how
lord,
many witnesses have been?
That time, my lord, two numbers of witnesses.
on 18/7, both were present, my lord. But the court did not examine. On 18/7,
not
both
be
examined. It is on the record, my lord. Kindly see, my lord, order dated 18/7/2024. Although there is direction, my lord, by your lordship, my lord, within 3 months, and 3 months have been elapsed on 12/5, 12/8, my lord.
We are fixing it on 20. One more. What happens on 17, let us see.
My humble submission, my lord, your lordship, on the last occasion in 14/8, your lordship, and that fixed on 3/9, my lord, to complete in 1 year, 6 months, my lord. And whether within 1 year, 6 months, any have been, any witness examined or not. And no one is examined, my lord, till date, and 18/7, both the PWs are present also. But till they did not examine, my lord. It is not the fault of the PWs. And it is not the fault of the petitioner, my lord, from the part of the petition. And in respect of the merit of the case also, my lord, this is also, my lord, there is a lacuna from the part of the prosecution.
Where is the lacuna?
My lord, it cannot be said that it can be taken from my possession. Because, my lord, one Azaduddin, my lord, one Azaduddin house it was recovered. They are saying that. And Azaduddin was not made as a party, not made as an accused here, my lord. And it is their statement also that it is received from the another area where I was not that area.
Who are these Makram Ali and Salman Khan? They are Caesar witness.
My lord. My lord, here, that is the, as stated,
We are
my lord.
fixing it on 20 with a report. Today is
My lord, my submission, my lord, there is no lacuna from my part of the petition. From
No,
my part,
but 37 is there. You cannot
My lord.
assume that as soon as 1 year, 6 months is over, you are entitled
this is right,
to.
my lord, this is right.
Even my lord, though
Because
this,
witnesses have appeared. Suppose they appears on 17 and does not say anything against you. Then also your case. There are 6 witnesses. 6 witnesses can be examined on a single day.
my lord, but my lord, maybe same time as because there is no exclusive, court. Man, only one court that is also not functioning, my lord.
Third,
Lord,
Mr. H.R. Chaudhary, learned counsel for the petitioner. Also, heard Mr. K. Bush, learned additional public prosecutor. Also peruse the status report furnished by the learned Sessions Judge Karimganj as directed by this court. Status report of special NDPS case number 19/2023 furnished by learned Sessions Judge Karimganj as directed by this court. Stop. On perusal of the status report, it appears that the aforesaid case was fixed before the trial court on 18/7/2024, on which and on the said date, two witnesses had appeared before the court, however, they could not be examined on that day. And the next date is fixed again on 17/9/2024. Stop. Considering the above facts, let this case be listed again on 29/2024. 29/2024. Stop. The learned Sessions Judge Karimganj is directed to furnish a further up-to-date status report as on 17/9/2024, along with the copy of deposition of witnesses, if examined on that day, the said status report and the copy of testimony of witnesses should reach this court on or before 19th of September, so that same can be placed along with this case record on 20th September. List this case accordingly on 20 September.
Order,
Leave your place.
May it please the lordship. My lord, it is the second appeal of 2010, my lord. Now, both the parties have filed this joint petition, my lord. They have compromised the matter outside the court, my lord. And there is an agreement signed by both the parties. It has been annexed at Annexure A, page 15, my lord. Under order 23, rule 3, my lord, this compromise petition has been filed after they have been attained the matter by an agreement in between them.
Yes.
My lord, your lordship, kindly see page 15, Annexure A in this IA, my lord, is an agreement. Operative part starts from page 16, deed of agreement, dated 29th July 2024. Both the parties are from Silchar, and they decided the matter in between the parties, and this agreement was signed by both them before the notary on 29th day of July 2024. And my lord, operative part starts at page 18, paragraph . Your lordship has got a second paragraph, my lord, at page 18. Whereas now the second party respondents on receipt of the handsome amount in full has settled the dispute amicably by way of mutual discussion between the parties, do hereby relinquish all rights and title interest
and claim whatsoever in respect of the property as mentioned in the registered deed, so and so, so and so, so and so, as mentioned in schedule 2 of the total measure. So, my lord, this deed of agreement has been signed, and it is also annexed to the sketch map in between the parties. So this matter may be kindly closed on the basis of the agreement they have attained in between.
Yes,
Lordship, we already compromised, Lordship.
okay. Heard.
And this agreement will remain a part of the degree, my lord. It will be, the degree will be
Heard,
prepared
Mr.
on the basis of this.
M.H. Raj Bordmia, learned counsel for the applicant. Also, heard Miss, what is your name?
Miss A Begum, I'm appearing on behalf of Mr. A M Borguia.
Miss A. Begum, appearing on behalf of Mr. A.M. Bordmia, learned counsel for the respondent. This interlocutory application has been registered on filing of a joint compromise petition under Order 23, Rule 3, read with Section 151 of the Code of Civil Procedure by the appellants as well as respondents of regular second appeal number 188/2010. Stop. Learned counsel for the petitioners, learned counsel for the applicant slash, you are appellant or respondent?
We are appealing before the High Court, my lord.
Learned counsel for the applicant slash appellant as well as the respondents have submitted that both the parties have amicably settled their disputes and to that effect have executed a deed of agreement on 29th day of July 2024. Stop. Learned counsel for both the sides have also submitted that the pending regular second appeal number 188/2010 may be disposed of in terms of the settlement reached between the parties and the deed of agreement dated 29 July 2024 may be formed as a part of the decree. Stop. Considering the submissions made by learned counsel for the parties as well as considering the application and as well as the annexed documents therewith, this court is of considered opinion that both the parties of regular second appeal number 188/2010 have amicably settled their dispute and the appellant of RSA number 188/2010 have also agreed not to pursue with the said appeal. Hence, this interlocutory application is disposed of with an observation that the connected regular second appeal number 188/2010 be closed as the matter has been amicably settled between the parties and be closed as the matter has been amicably settled between the parties. Stop. This interlocutory application is allowed, accordingly allowed. Next in RSA Likibo, this regular second appeal heard Mr. M.H. Raj Bordmia, Also heard Miss A. Begum, learned counsel for the res- respondent. Rajput Mir, learned counsel for the appellant. In terms of the orders passed on 3rd of September 2024 in IA number 2633/2024, both the parties here to have amicably settled their disputes and have agreed to not to pursue with the appeal. Stop. In view of the above, this regular second appeal is disposed of on composition. Let a decree be prepared accordingly. Let the deed of settlement reach between the parties, which is annexed as annexure A along with the interlocutory application numbers 2633/2024. B form a part of the said decree.
Next slide.
With above observation, this regular second appeal is hereby closed.
Next slide.
Wait, please, Lordship. Madam, we asked over for the time being, Lordship. My senior is on place.
Lordship, I have got time being in 26 also, a criminal appeal.
Then at two.
Huh?
At two.
At 2, opposite at 2.
Two, we have a part heard matter.
Yes, because Lordship heard it. I do not know.
Part heard matter, Lordship. At 2, Lordship.
remembered.
Not at two, we have already a,
Yes.
Possible for the time being, Lordship. It's near time.
okay, we'll see. After two, if possible, we'll take it up, otherwise we'll adjourn it.
Then let it be adjourned because Lordship, I have a jail appeal. I cannot take adjournment in that and that is of
Okay.
2010. If I ask for an adjournment in that court,
For the
Heard,
time being, Lordship. Time being.
no, 5 তারিখে লইব। পরহির কানে লইব। To be in a comfortable way, and normally next Tuesday লইব।
My senior may not be available on that day, Lordship.
নহয়,
Let
তোমাৰ
madam
চিনিয়ৰৰ লগতেতো এদিন আছেতো মোৰ হেৰি ছেপ্টেম্বৰৰ এণ্ডত 17th লৈ যোৱা সুধি লোৱা নহ'লে ডেটটো কৈ দিবা 17th I think I have
okay, we'll pass orders after some time. Let
After
him,
some time,
let him
Lordship.
find out convenient date from his senior.
Lordship,
let
after
it
some,
be on a Tuesday lot
Okay.
because already
after some time, Lordship.
We are going to adjourn it. But you just tell us the convenient date. After some time, you tell us
Lordship.
your convenient date.
obliged to 14 the night
Please, Lordship, the respondent has not appeared today, so matter may be fixed on this Saturday, this Thursday, Lordship, for hearing.
Thursday, this bench is not sitting. Oh, Thursday. In other courts are there. Heard Miss, what is your name?
PCB Nair, Lordship.
Heard Miss PCB Nair, learned counsel for the petitioner. Learned counsel for the appellant. None has appeared for the respondent on call. Let this matter be listed in the next week on a date to be fixed by registry.
The date may be fixed, Lordship.
No, registry will fix the date in the next week.
Lordship, kindly a date may be fixed, otherwise. Achha.
May I please your lordship, my lord? My name is shown in the respondent, my lord. I am not in the case. The brief has been taken out. So my lord, the name, my lord, KD Chetri, IB Kakoti and Rima Bora should be struck out, my lord. Because the file has taken out, my lord.
The respondent
Yes,
has,
sir.
who is for the appellant?
Appellant for the appellant is KR Patgiri, my lord. I am not in the case. File has been taken, my lord. So my name is shown, that should not be shown, my lord. No problem.
None has appeared for the appellant on call. Mr. KD Chetri,
IB Kakoti and Rima Borua, my lord.
Miss IB, Mr. KD Chetri, whose name has been shown as counsel for respondent in the cause list, submits
When
that
I will file to legis.
the respondent has already taken back their brief and they no longer represent, and he, along with Mr. IB Kakoti and Miss Rima
Rima Borua.
Borua, do not,
R Borua.
R Borua, no longer represent the respondent, and therefore their name may not be shown as their engaged counsel in the cause list. The prayer is allowed. The registry shall henceforth will not reflect the name of Mr. KD Chetri, Miss I.B. Kakoti and Mr. I.B. Kakoti and Miss R. Borua in the cause list as engaged counsel for the respondent.
Yes, highly obliged.
Let this matter be listed again. LCR, I see.
With
Again,
LCR, now.
again after 2 weeks on a date to be fixed by registry.
We highly obliged.
May I please your lordship? My senior learned counsel D Saraf is out of station for her mother knee injury operation. So kindly allow some time and kindly list the matter after next week.
Heard, Mr. What is your
D
name?
Sharma,
You are for?
D Sharaf, a respondent.
Who is for the appellant?
I am for the appellant.
What is your name?
K. Rajkot.
Heard
Yes.
Mr. K. Rajkot, learned counsel for the appellant. Also heard Miss B. Sharma, learned counsel for respondent number 1, 2, 3, who submits that her senior Mr. D. Saraf, who is the conducting counsel for the respondent, has some medical urgencies to attend. Hence, she prays for an adjournment in this case. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Highly obliged.
Please, your lordship. Lordship, due to some personal difficulty today, my senior couldn't appear in this matter, lordship. So, kindly matter may be fixed after puja vacation, lordship.
Lordship, my only prayer is, since the matter is fairly covered with the decision of the full bench of this honorable court, Lordship, let it be fixed after puja vacation, Lordship. A date may be fixed, so it can be
After
discussed.
puja vacation,
Like, Lordship, as per their convenience.
No.
Because the council also not available. So he's asked me to like list it after vacation.
we'll fix it after vacation, but no dates. Registry will fix it. Heard, Miss, what is your name? N. Sharma, learned counsel for the appellant. Also heard Miss
Sharma.
M. Sharma, learned counsel for the respondent. It is submitted by learned counsel for the appellant that conducting counsel Mr. G. N. Sai.
K. Gogoi.
K.
Gogoi.
Oh, sorry. Conducting counsel Mr. K. Gogoi is out of station and therefore prays for fixing this matter after puja vacation. Learned counsel for the respondent submits that the issue involved in this appeal is covered by a decision of full bench
Passed in WA 333 of 2010.
of this court in writ appeal number
333.
triple
Oblique
three of
2010.
2010. And she also prays that she does not opposes the prayer for adjournment of the learned counsel for the appellant. Hence, the prayer is allowed. Let this matter be listed after puja vacation on a date to be fixed by registry.
Oblique.
Item number 11, Malad. My name is Shori Malad. I am but my name is Malad. What is in the order? Item number 11.
11, K.R. Padgiri. Oh, yes, in item number 11,
11.
item number 11, वो order में वो लिख देना, heard Mr. K.R. Padgiri,
Malad.
learned counsel for the appellant.
Malad.
Then make submission made by K.D. Chetri.
Malad.
Lord, this case was earlier occasion, your lordship was heard also.
I have heard.
Yes, yes. But on that day, senior counsel for the other side is also coming, my lord. In nutshell, can I only brief?
Who is representing?
He's on his way, your lordship.
He is on the way. In nutshell, I can start the pleadings, then he may submit.
Yes. You may at least tell me the facts.
Facts, only facts. In facts, I may.
Yes.
On facts.
Ms. Sharma, you remain.
No, wait, why?
You make a call and then take notes. You can go and make a call, inform your senior that the other side counsel is submitting on facts till he appears.
My lord, there in this case, in 2007, I have filed a suit. Why?
Yes.
My lord, your lordship may take up the second appeal too, my lord.
2 and 1 are the same only.
No, but Shankar Das might be taken up.
No, one copy I have.
Shankar Das
one.
will be taken up.
Shankar Das.
আমাকে একটা শঙ্কর দাসের আয়ের কপি একটা দিয়ে দিবেন। এদিনও বলছিলাম আয়ের কপি, হ্যাঁ এদিনও বলছিলাম তারা দিল না। আয়ের কপি
আচ্ছা হবে, আপনি করেন তারপর আমরা আমাকে পরে দিলে হবে।
My lord, may I see the order dated 31/3/21. The three grounds has been substantial question law has been framed.
3110.
31/3/21. My lord, three substantial question law has been framed.
Yes.
My lord, whether the appellant could establish his possessory right in the premises since 1981, independent of the right of the decree holder, and thereby decree holder is not related to the decree. My lord, first thing, my lord, when an application is filed by a party, my lord, who is not a party to the suit under order 21, rule 97, 99,
my lord.
No, before that, you have to brief me about the facts. Little.
My lord.
What happened?
The facts is this, my lord. The respondent filed a suit,
Present respondent.
present respondent, my lord, filed a suit against some fixed persons, actually. They were not in the position of the suit land.
Okay.
So on
Filed a
coming,
title suit for
eviction of that,
eviction.
my lord. Then on coming to know about the suit, my lord, we filed an application under order 1 rule 10 for aiding us as a party. My lord, that application was rejected. Thereafter, we come to the High Court in division. The divisional court says that you have a remedy under order 21 rule 97, 99. So if any decree is passed, then you can file a petition because you are not a party to the suit. Now, if you also see the IA, my lord, in the case 805.
805.
805, IA.
IA filed to the Putur. IR file. 805. Yes.
My lord, here, this suit has been filed by Pankaj Sarda against Basanti Singh and others. Now the question is this, my lord, if Pankaj Sarda has purchased the land from somebody else who purchased the land from the Waqf, well, yeah. Now this order dated 24/7/2009, you see, my lord.
24.
24/7/2009 at page 14, annexure 1. How a Portland decree has been passed. Plaintiff is defendant. You also got it.
Yes.
Defendant is also present. Defendant by petition number admitted the case of the plaintiff. Petition is supported with affidavit. I heard both sides. The suit is decreed or admitted. Around the first day, say first.
No, not on
First day or second day, whatever it
No,
may be.
it is after 2 years.
Maybe, because we filed the petition, that is why it was delayed. We filed the petition order
after
1
2
rule 10.
years.
We filed the. So, defendant has not filed the WS. Defendant has filed, my lord, the petition that admitted the case of plaintiff. So, virtually this is a collusion victim.
Pankaj Sharda is the respondent here.
Yes, my lord. Pankaj Sarda is there.
Okay.
And
This is in respect of which property?
my lord,
Which
Kas- Kasar.
suit property is?
in Kasar district.
How much land?
Yes, land is, my lord, understood. If you also see, my lord, that the decree is there. At this page, my lord, it is at page 17, my lord.
— 17 feet. It is a Assam type house.
Assam type house measuring 17.5 feet in length, east and west, and 63.7 feet in breadth over holding number so and so, Silchar Municipal Board, with electric connection bounded by so and so.
Okay.
This suit, my lord, the plain as such it is at page 25.
Page
25. Here, my lord, para 2 at page 26, you will also see the suit piece originally belonged to Sri Horichand Sarda, son of so and so, so and so.
This is the plaint.
My lord, plaint. Having non-evictable leasehold title under Sri Mahaprabhu Vigraha of so and so, Sri Horichand Sarda granted lease of the structure described in schedule below in favor of Ram Niranjan Singh, son of late Ramlal Singh, and petition interest of the defendants. And Ram Niranjan Singh used to conduct his business.
This is, my lord, in this way you have to. Now, in this matter, my lord, we have filed the petition. If you also see the petition filed by us, that is at page 51, my lord. This is the important, my lord. Here, this is the our petition, on the basis of which, my lord, order 21, rule 9799, the petition, page 31.
This I was for suspension, for,
My lord, declaration of independent right.
no, this I.
Oh, IA for stay, my lord.
Stay of the
Yes, yes.
execution.
Yes. The here, my lord, I have given.
Stay
the-
was granted.
Yes, stay was granted.
Okay.
If prior to that, my lord, if your lordship, my lord, may I place, my lord, the decision of one Supreme Court judgment, my lord, what is, my lord, the right, my lord, and what way, my lord, the case to be decided under order 21 rule 9799. My lord, learned trial court as well as appellate court has gone wrong totally, my lord. This honorable court has framed the issue properly. Para 40, my lord, of this judgment, your lordship.
Yes.
In determining as to whether the bar constructive reciprocal sales affected in necessity advert to earlier application which was filed by the appellant and this motion. The appellant styled one of the order 21 rule 99, but in our view, not determinative, the true nature of the application order 21 rule 97 provides. Where a decree holder holder of a decree for possession of real property or the purchaser of a property sold in execution decree resisted or obstructed by any person in obtaining the possession of the property, he may make an application to the court complaining of such resistance or obstruction. Where any application is made under sub-rule 1, the court shall proceed to adjudicate upon the application in accordance with the provisions herein contained. Order 21 rule 99 provides. Where any person other than judgment debtor is dispossessed of your property by holder of the decree for possession of such property or where such property has been sold in execution decree by purchaser thereof, he may make an application for a court complaining of such disposition. Where such application is made, the court shall proceed to adjudicate upon the application in accordance with the provisions in the convention. In Brahmadev Chaudhary versus so, the court held that the view taken by the High Court that only remedy available to a stranger to a decree who claims an independent right, title interest in the property is to pursue the remedy under order 21 rule 97 was unsustainable. The court held that a stranger to a decree entitled to agitate his or her grievance and claim for adjudication of his independent right, title, and interest in the ancestral property, even after being dispossessed in accordance with order 21 rule 99. Order 21 rule 97 deals with a stage which is prior to actual delivery of possession, and the grievance of obstruction can be adjudicated upon before actual delivery of the possession or decree holder. In other words, both sets of remedies are available to a stranger to a decree. The High Court totally ignored the scheme of order 21 rule 97 in this connection by taking the view that only remedy of such stranger to decree lies on up under order 21 rule 99 and he has no locus standi to get adjudication of his claim prior to actual delivery. Well, I am skipping over. I am not.
What happened in your case? What has?
We have not, we filed the petition prior to our disposition.
Order 21 rule 97.
97, 99.
Thereafter?
Thereafter, that has been executed. Now, your losses may come to para 43, madam. Under order 21 rule 101, all questions, including questions relating to right, title, interest in the property arising in the parties were proceeding on an application under rule 97 or rule 99 or their representatives shall be determined by the court and not by a separate suit. So speaking for two judge bench, while interpreting the expression any person in rule 97 held us, we find the expression any person under subclause 1 is used deliberately for widening the scope of the power so that executing court could adjudicate the claim made in any such application under Order 21 Rule 97. Thus, by use of the words any person, it includes all persons resisting the delivery of poison, claiming right in property, even those not bound by the decree, including tenants or other persons claiming right on their own, including insider. These principles have been reiterated in Harbilas versus Mahendra, in which it is held that provisions of Order 21 Rule 99 would not defeat the right of a third person claiming to be in possession of the property, forming the subject matter of a decree in its own right. Well, this is the main crux which is to be decided, that whether I am in possession of my own right, independent of the decree. So this is the issue to be decided here. Objection decided under Rule 97 at the stage prior to disposal. In succinct of this is so and so. From the rule executed above, it is easily seen that the language of the rule is peremptory, and the powers given to the executing court under this said rule is plenary. The powers given to the executing court under Rule 101 are not qualified or held by any restriction. On the other hand, it shows that the executing court is required to execute upon all the questions mentioned in the said rule, as if it had the jurisdiction to deal with every question that may arise. By legal fiction, an executing court which may otherwise have no jurisdiction is invested with their jurisdiction to try all questions under the aforesaid rule. In view of the settled position of law, as it emerges from above, the decision it is evident that appellants were entitled, though they were strangers to the decree, to get their claim to remain in possession of the property independent of the decree executed in course of execution of proceeding. The appellants in the facts set up a claim. They sought a declaration of their entitlement to remain in possession in the character of a lessee. Under Order 21 Rule 97, they were entitled to set up an independent claim even prior to disposition. Under Order 2101, all questions have to be executed upon by the court dealing with the application and not by a separate suit. Upon determination of the questions referred to in Rule 101, Order 21 Rule 98 empowers the court to issue necessary orders. The consequence of the execution of a decree under Rule 103, the claim which the appellants have now sought to assert the compensation, well, this is not necessary. So the question, my lord, which is to be decided is whether I have an independent right to possession of the property or not, then the decree order. This is my question. Because I have not been arraigned as a party. Although I filed a petition, I was not arraigned on the ground that, my lord, I can file a petition under Order 21, Rule 979.
No, but what has happened in this case? In this case, what are the facts?
Facts.
He filed a suit against a different other
It is a
person.
person who is not in possession of the property. my lord.
Yes, that is your claim.
That is my claim.
After he got the decree,
Yes.
when he went for execution of the
Yes,
decree,
my lord.
you filed an application
Yes.
under Order
21 Rule 97, 99.
97 and 99, both.
Yes.
What happened to that?
That was rejected. Then I filed an appeal.
Rejected on what ground?
On the ground that, my lord, I could not prove that I am not a non-evictable tenant.
Okay.
My lord, that is not the question, my lord. Although I have said that I am non-evictable tenant, whether I can prove it or not, but whether I have tenant independent to that of the decree. That is to be proved, my lord.
Oh,
So
as because, as
child
because-
has gone wrong on that aspect of the
okay,
matter.
your submission is as because decree was not against you.
My.
Therefore, the question of non-evictable tenant.
But it's not necessary, not necessary at all. Although I have pleaded in the case that I am non-evictable, but whether I have proved or not, but at least whether I am a tenant or not of the other party, independent to the decree holder.
So if it is found that you are a tenant,
Yes,
then what
then the decree cannot be executed against me, my lord. They have to file a separate suit.
separate suit?
Separate suit for which
That is your plea. Then what happened in the appellate court?
appellate court also on the same line, my lord, they dismiss my appeal.
Okay.
I can place, my lord, that no. My lord, your losses may come to page 58 of trial court's judgment.
India A.
IA. IA also is there, here also it is there, but IA also is also in the C.
Page 58.
Yes.
Yes.
The particular case in brief is that the scheduled land measuring 9 set of 10 ganda, covered by a second IS pattern number so and so. Partly more of Silchar town, so and so. Barakpar, with two-state all Assam type structure, including holding number 332, old 321 new, of other which Silchar municipality owned by Sri Mahaprabhu Vigroho of Janigan Bajar, and the same was taken on settlement by Ramjanjan Sikh in the year 1945 on the condition to pay annual rent and Mohim Plovadjo. Well, this is supported by the plate also, who inducted into position. Both Ramjanjan Singh and Mohim Chandra Shuklavadjo constructed permanent houses thereof at their own cost. And the names of Ramjanjan Singh was mutated in the municipal holding as owner, and Mohim Chandra Shuklavadjo was shown as holding in the holding as an occupier. There was mutual agreement between Mohim Chandra Shuklavadjo and Ramjanjan Singh, whereby Ramjanjan Singh, on receipt of valuable consideration, relinquished his lease right in respect of his scheduled land and allowed Mohim Chandra Shuklavadjo to take settlement from the landlord as a tenant, to which landlord accepted him as a tenant by accepting rent and issuing rent receipt, accordingly paid rent, and rent receipts were issued. Mohim Chandra Shuklavadjo, having constructed permanent structure over the scheduled land, acquired non-effective occupancy right under Assam Non-Agricultural Urban Area. During the lifetime of Mohim Chandra Shuklavadjo, he let out the scheduled premises to the petitioner by executing a deed of acknowledgement, and the petitioner continued in possession of the scheduled premises from April 1980 onwards. On death of Mohim Chandra Shuklavadjo, his son Manik Chandra Shuklavadjo made over possession of the scheduled premises to the petitioner in the year 1994 on receipt of valuable consideration and relinquished all his rights, and subsequently Vidhan Shuklavadjo executed an unregistered deed in the year 1996 and relinquished his right title and interest over the scheduled property. Well, this is my case, madam. My case is this: originally, well, the Ramjanjan Singh with the tenant under the work property, my lord. Then
It is Mahaprabhu Vigraha.
My lord, yes, that was Vigraha. That land, my lord, here question is this also, my lord. Actually, Vigraha property cannot be sold by the my lord. It cannot be sold. It's a Devatar property. Now,
No, not Devatar.
huh? Yeah, Vigraha,
Not Devatar.
may not be so. Charitable trust. Now, the petitioner contends that he paid the annual rent for the land and premises to the landlord Sri Mahaprabhu Vigraha and obtained receipt thereof. The petitioner carries on business of bookbinding and printing in the name and style of Shankar Bookbinding and printing works at Jani Bazaar, and obtained trade license in the year 1988 for carrying on his business. The petitioner contended to be in uninterrupted physical possession over the scheduled land and house on his own right for more than stipulated period to the knowledge of the decree holder and the judgmentator on payment of annual rent to the landlord and municipal taxes, and thus acquired non-effective tenancy right under the Assam Non-Agricultural Urban Area Tenancy Act 1955 for the scheduled land and Maliki right over the houses standing there. The petitioner has prayed for declaration of his non-effective tenancy right and Maliki right over the decretal scheduled land of so and so, and confirmation of his possession over the scheduled land holding that the decree of so and so is not executive and binding on him along with other elements. Though he filed written objection and denied the claims of the petitioner and contended that Sri Harichandra Sarwa acquired title over the scheduled land by virtue of purchase by registered salary number from the original owner Sri Mahaprabhu Vigraha deity. Ramjanjan Singh was a tenant under the original owner landlord Sri Harichandra Sarda in respect of the suit holding. He died leaving behind his wife as only surviving legal heir, and she became the exclusive tenancy right over the suit property. On the death of his wife, Ram Ranjan Singh, the tenancy right devolved upon Sundar Singh, brother of wife of Ram Ranjan Singh, and Sundar Singh died leaving behind only son Bindeswari Singh. And he obtained the trade license to conduct the business for suit premises. The OP contends that the petitioner does not have any legal rights or claim title over a suit premises in any manner. The OP contends that at no point in time Mohit Chandra Shukla had acquired any non-effectible tenancy legal the right over any portion of the suit land and denied the claim of the petitioner of acquisition of title from the legal heirs of Mohit Chandra Shukla. Horizon Sarda transferred his right title interest of the over the decretal property by salary number so and so. Registered in the office of the deputy registrar Kachar Silchar, and by such purchase, the OP became the owner of the suit premises in the capacity of the owner landlord. After acquisition of ownership title over the suit premises, the tenants were informed, and after death of Bindeswari Singh, the legal heirs became the tenant, and as such, they were defaulter and they were bona fide required. OP filed the suit against the legal heirs of Bindeswari Singh from the suit premises and received the summons. Defendant gave the settlement to the plaintiff to agree to vacate the suit premises in their occupation on receipt of rupees 1 lakh. Accordingly, they filed the petition admitting the claim of the plaintiff in title suit number so and so, which was decreed on so and so. But as the defendant did not vacate the suit premises within 15 days as per settlement, OP as a decree holder filed the title execution case and deposited the requisite amount to challenge. OP decree holder contends that before the lawful decree can be executed, petitioners with malified intention in police, the legal heirs of Bindeswari Singh filed a false case with a claim, false claim in respect of the suit property and paid for dismissal of the missed case. The following issues were framed: whether the misdisposition and whether the petitioner have non-effective tenancy right over the land, maliki right, and possession of the dictated premises. In title suit number so and so. So far, order 21 rule 95 is concerned, my lord. Virtually, my position is sufficient, independent position. Whether decree holder has right title interest over the decreed property, whether decree is executable and binding upon the petitioners, are the explanation. Issue number 1. My lord, this is decided in my favor, so not necessary. 2. Issue number 2, next page, page 16. Petitioner contends that Ram Ranjan Singh took settlement of the scheduled land in the year 1935 from the owner landlords in Mahaprabhu Vigraha on the condition of payment of annual rent. Ram Ranjan Singh inducted Mohit Chandra Shukla and both of them constructed permanent structure thereon at their own cost, and Ram Ranjan Singh mutated his name in the municipality holding, and Mohit Chandra Shukla was shown in the holding as an occupier. The petitioner exhibited certified copy of the assessment register of 1998-99 in respect of holding number 321, ward number 6, as exhibit 1, and the relevant entry showing the name of Ram Ranjan Singh, owner of the holding, as exhibit 1, and the entry showing the name of Mohit Chandra Shukla as occupier of the holding. Now, this is very important. As exhibit 1. The petitioners contend that assessment register of the column number 10, the area of the said holding is mentioned as 1 kata 3 stack, and the description of the building is shown in column number 11, and the year of construction is shown as 1945. As per section 333 of the Assam Municipal Act, the word occupier includes the person for the time being receiving rent of any land or building or any part of any land or building, whether on his own account or as an agent or trustee of any person or society for any religious or charitable purpose, or as a receiver who would so receive such rent if the land, a building or any part thereof were related to a tenant. As per section 331 of the said act, occupier means the person who for the time being in actual possession of or paying or liable to pay owner rent or any portion of the rent of the land or building in respect of which the word is used includes a person occupying the holding or part of holding rent free and owner living in his house. The definition of the word owner as provided in the act does not go to show merely person who has been described as owner of the holding title based upon him. The assessment register, not a document vesting title. On the basis of the entries, title to the house cannot be established. As per section 3G of the Assam Non-Equal Tenancy Act, tenant means a person who holds land under another person or other than government, and who is for a special contract liable to pay rent to the latter, and includes a person who derives his title from a tenant and a person who continues in possession of any land after termination of the tenancy in respect of survey. As per section 5(1) of the Assam non-legal tenancy, Act, this is not necessary at all. I'm not.
No, it was pleaded, my lord. It is
Yes.
necessary.
Where
They have pleaded in
yes.
the plain.
pleaded, no,
It is
where under the terms
plain
of the contract
case.
entered between the landlord and his tenant, whether before or after commencement of the act, the tenant is entitled to build or has in pursuance of such tenancy actually built within a period of 5 years from the date of such contract, a permanent structure on the land of the tenancy for residential and business purpose, or where a tenant or not being entitled to build has actually built any such structure on the land of the tenancy for any of the appropriate purposes with the knowledge and acquiescence of the landlord, the tenant shall not be ejected from by the land from the tenancy except on the ground of non-payment of rent. It appears from the petitioner has not produced any document so the terms of settlement of the tenancy between Ram Ranjan Singh and the original owner landlord Sri Mahaprabhu Bigroho. There is no document to show the settlement took place in the year 1945. There is no evidence on record to show that Ram Ranjan Singh and Mohim Chandra Shuklavadya constructed permanent structure within 5 years of the tenancy. There is also no evidence to show that prior permission for construction of permanent structure was obtained from the concerned authorities by Ram Ranjan Singh, Mohim Chandra Shuklavadya. There is no evidence to show that Ram Ranjan Singh relinquished his right over suit land and scheduled land was settled with the Mohim Chandra Shuklavadya. The petitioner produced rent receipts showing payment of rent by Ram Ranjan Singh to the landlord and exhibited the same as exhibit 22122. The petitioner exhibited the municipal tax receipt 33 holding Ram Ranjan Singh. PW1 contended that during the lifetime of Mohim Chandra Shuklavadya, he let out the scheduled premises to him by executing a deed of Akranama dated 15/10/80, and he was continuous possession of the same. The Akranama has been executed exhibit 4. The petitioner failed to probe exhibit 4 document. On the death of Mohim Chandra Shuklavadya, his son Manik Chandra Shuklavadya made her possession of the scheduled premises to petitioner in 1994 on receipt of valuable consideration and relinquished his right. The petitioner exhibited the said memorandum as exhibit 5 with signatures of Mohim Shuklavadya as exhibit 5(1) and Mohim Shuklavadya as exhibit 5(2) and Manilal Sahani as exhibit 5(3) and Parish Das as exhibit 5(4). Vidhan Shuklavadya executed an unregistered deed in the year 1996 and relinquished his right, title and interest over the scheduled property. The petitioner exhibited the said memorandum as exhibit 6. P2 in his cross-examination reports that he was not a witness to any of the settlement between the Manik or Mohim Shuklavadya and Sankatas. He also did not know any settlement between Mohim or Mahaprabhu Akra. He also reported that he was not a witness to any deed purchase of settlement Sankatas from Manik Shuklavadya. The petitioner exhibited rent receipt issued by Sri Binod Ranjan Chakravarti, Civate of the landlord, showing payment of rent by him as exhibit 7. It appears that the petitioner claimed to be tenant under the landlord Mahaprabhu Bigroho, but the said landlord deity has not been made a party in the present case. My lord, very interesting, this is not my case. Moreover, the rent receipt exhibited by the petitioner has not been proved. Mere payment of rent does not necessarily establish the relationship of landlord and tenant and may only prove permissive occupation, not amounting to any right or title to that position. So, at least, my lord, my occupation has been founded. I am in occupation. Section 54 of the Transfer of Property Act provides that the transfer of tangible property of value 100 and upwards made only by registered instrument. Section 110 of the Indian Evidence Act provides that when the question of any person, owner, anything which is shown to be in possession, burden of proving that he is not the owner, is on the person who affirms that he is not the owner. It appears from that OP is exhibited certified copy of the registered sale deed number 12, that number 12 dated 3/3/58, showing purchase of scheduled land along with other lands from Sri Mahaprabhu Bigroho by as exhibit 1. His Jamamandir Surpata as exhibit B, showing the mutation of Sri Mahaprabhu Bigroho, Horizon Sarda, and certificate of the registered sale deed number so and so, has exhibited exhibit C. In support of the title of our scheduled property, has been able to discharge the party. The petitioner thus failed to prove their non-effective tenancy right over the land and Maliki right and possession over the dictated land. Well, this is the, that's, here what happened. I am the tenant. I have purchased the right. It may be, unregistered deed, my lord.
You're claiming tenant of
Tenancy since 1980. And thereafter,
Mahaprabhu Vigraha.
Mahaprabhu Vigraha, I was paying the rent because original tenant was also tenant. Thereafter, I have purchased the right of the occupier by unregistered deed. My lord, the tenancy deed and the deed may not be registered, my lord. But those can be taken up for collateral purpose. Collateral purpose showing that I am in possession of it. For collateral purpose, it can be used.
Yes.
My lord, here, my lord, the other documents has not been considered. The municipal license and other things, because I am running a printing, my lord, business there. And we have license and other things are there. I shall place, my lord, those documents. He has not considered this. The trial court has not considered all those documents. Showing that I am in possession of that property and I am running my press business from there. Now, issue number 3. Whether decree holder OP number 1 has right at interest over the decreeable. OP contended that Mahaprabhu Vigraha was the original owner of the suit property who sold the land to Horizon Sada. Well, can this Vigraha property be sold in such a manner? We don't know anything. Anyway, my lord, I am not on that also now.
It's not challenge.
Now, whether decree holder has the right title or interest, that has already been decided in the.
Well, that I am not.
In the present case also.
So this issue, my lord, may not be done. So now
What's the important issue? Whether I have a right title in property.
maybe you have a right title interest.
But that was decided in the admission decree also.
Admission degree as well as this present case also.
My lord, I shall place this also. OP contended that she is Mahaprabhu Vigraha, the original owner of the property.
Which page?
Issue number 3.
Issue number 3.
Who sold the said land to Horizon Sada by registered deed number so and so. That is 3158. Ramchandra Singh was the tenant of the owner. My lord, it is admitted, my lord. Landlord.
Ram Niranjan was it?
Yes. Horizon Sada, in respect of the suit holding, has obtained mutation from the Silda Municipal Board. He died leaving behind his wife, only several legal years, and became exclusive owner of the tenancy right over the suit property. The death of Ramchandra Singh, the tenancy right devolved on Sundar Singh. And Sundar Singh died leaving behind his only son Bindeswar Singh. He obtained trade license to conduct the business plus property. Copy contends that prisoner do not have any legal right to claim over the claim title of a suit premises in any manner. OP contends that at no point I am Mahinchandra Suklabhaddha acquired in non-effective tenancy leasehold right over any portion of the suit land. He denied the claim of the prisoners of acquisition of title from the legal heirs of Mahinchandra Suklabhaddha. Horizon Sada transferred and conveyed his right title and interest over the decreed property by registered sale deed number so and so. The office of the deputy registrar Silchar and such purchase become the owner of the suit property. OP exhibited certificate copy of the registered sale deed number so and so as exhibit showing the purchase of scheduled land along with other lands from Sri Mahaprabhu Vigraha. Jamabandi of the suit patta showing mutation of the name of the Mahaprabhu Vigraha. And Horizon Sada also exhibited exhibit B certificate copy of the registered sale deed in support of their title over the scheduled property has been exhibited exhibit C. Certificate copy of the sale deed is as good as original. My lord, this is not correct, my lord. Certified copy cannot be, my lord. It's a secondary evidence. It's secondary evidence. It cannot be, my lord. Without the original, it cannot be proved also. Anyway, my lord. And its correctness is presumed, but mere registration is not a proof of execution. Defendants have also denied the execution of exhibit A and C deeds in their case. Proviso to section 68 of the Indian Evidence Act provides that it shall not necessarily call for an attesting witness in proof of the execution of the document, not being a will which has been registered in accordance with the provisions of Indian Registration Act. unless its execution by a person by whom it purports to have been executed is especially denied. Due to an examination in chief reports that he along with his brother jointly purchased the suit land by registered sale deed number so and so. Horizon Sada executed the sale deed in his presence and in presence of his brother Pankaj Sada, attesting witness Kantilal Mohanto so and so. P23 extra writer in the office of the deputy registrar Kachar Silchar appeared along with the book volume number so and so and executed in favor of Horizon Sada, Sibet, Dinot Chakraborty and Vijit Ranjan Chakraborty, and before the exhibit is the certificate of the deed. This issue is decided in FIR. Now, issue number 4, whether the decree number so and so executable and binding on the petitioner. The contents that decree so and so is not executable and not binding as they are strangers and third party. Finding issue number 2 shows that the petitioner failed to establish their non-executable tenancy right and maliki right over the civil. Well, this is wrong, my lord. I am saying. Original person was non-executable tenant or not, I could not probe is that. That don't mean that, my lord. I am not in the occupation of the premises. That is proved, my lord, that I am in the occupation of the premises. Supreme Court in Brahmadev Chaudhary held that a conjoint reading of order rules 97, 98, 101 project that if decree holder resisted or obstructed the execution decree for possession of the result of the decree for possession would not be executed in the normal manner by obtaining warrant of possession, then the decree holder has to move an application under order 21 rule 97 for removal of such obstruction. After hearing the decree holder and obstruction, court can pass an appropriate order after adjudicating the controversy between the parties with order 21 rule 98. If after such adjudication is found the resistance of or obstruction was occasioned with just cause by judgment or by some other person at his instigation on or behalf of the obstruction resistance would be removed as per order 21 rule 98 2 and decree order permitted to put in possession. The issue is dismissed. My lord, here you will also see, my lord, his petition, my lord, filed for the trial court. If you also will see, my lord, in the record, I have a Xerox copy also, my lord. Just can give you. That is the record, my lord.
It is in the record also.
In the trial court record, my lord, that petition and the documents as well. I am. Yeah. Record. My lord, he has not considered all the activities. না তার প্রটেকশনের অ্যালাউন্স করেছে ডকুমেন্ট গুলি My lord, will come to the annexures, my lord, in the petition. If your losses comes to annexures, my lord, executed documents. First one is the, my lord, the municipal board register, which was considered by the trial court. You also got it, my lord?
Yes.
This is the certified copy of the assessment register, my lord. Here, my lord, it has said that year of construction in 1945 is constructed. That is why, my lord, I have said that I'm not because and next page you will also find who is the owner, Ram Ranjan Singh. Occupier is Mohim Suklavarty. You also got it, my lord? Mohim Suklavarty is occupier.
Exhibit 1.
Yes, exhibit 1. Now, exhibit 2, if you also find, my lord, next page. The owner has issued receipt to.
How Mohim Shuklapadhyay is related?
My lord,
How Mohim Shuklapadhyay is
but
related?
he was the occupier, my lord. Both Ram Ranjan Singh and Mohim Suklavarty both constructed houses.
Okay.
Both constructed houses.
Now you are Now, who is Sita Devi?
But he has taken on rent, my lord, from Mohim Chandra Sukhavaidya. And there are the purchase date. Shankar Das, my
Shankar
lord.
Das has taken.
Shankar Das, yes, yes.
From Mohammed Suklabuddin. Okay. So your case is that Mohim Shuklapadda was occupier
Yes.
and you took the premise on rent from Mohim Shuklapadda.
Mohim Sukhavaidya, my lord. Because both Ramchandra Singh and Mohim Sukhavaidya constructed the houses and I shall place my lord other houses, which were not considered by that court. That too, my lord.
Okay.
Much.
Today.
Can it be on 13th? Friday?
Friday, it should be on a day like this.
Then on 17th? 17th is Tuesday.
Okay. 17 is okay. Item number 6, huh?
Yes.
Heard Miss R.D. Majumdar, learned counsel for the appellant, also heard Mr. S. Dotto, assisted by Mr.
M. Talukdar.
M. Talukdar. On request of learned counsel for both the sides, let this matter be listed again on 17th
September.
17th September
As part
as part heard matter.
Obliged.
Now. So now I am testing the exhibits, my lord. Next, you will also see, my lord, exhibit 2.
Now, by showing exhibit 1,
1, yes.
you want to say that the
That-
person from whom you took
Mohim
the
Chandra-
tenancy,
yes.
he
Mohim
was
Chandra Suklapadya
shown
was
as
in
an
first.
occupier.
Then subsequently, my lord, Mohim Chandra Suklapadya virtually purchased the right of Ram Niranjan and he was paying the rent to the
No,
original owner.
Before this, which issue we are discussing?
That exhibit 2.
First, no,
Exhibit 2.
we are discussing first substantial question of law for liberty.
Exhibit 2 is this, my lord. That Mohim Chandra Suklapadya was paying the rent to the original owner.
No, just in
That way.
in the memo of appeal,
Justice.
whether the appellant could establish his possessory right
Yes.
in the premises since 1980, independent of right of the decree holder. Now, whether this issue,
Hello?
possessory right, whether this was at issue between the parties, the
No.
trial court,
Well, it is a decree obtained by the respondent.
no, when you file your petition under order 21 rule 97,
Right.
some issue was framed.
Ah.
The
That,
issue,
that issue, my lord, that is what I am submitting. Issue has been framed whether I am a non-effective tenant.
tenancy.
My lord, but as per order 21 rule 97, 99, my lord, that non-effective tenant, not my lord. I may be a tenant. Whether effective or non-effective, my lord, here I am relying on the municipal record, my lord, that the building house was constructed in 1945. Ramchandra Singh is a tenant from 1945. Under that, my lord, that is admitted by the respondent also. So Ramchandra Singh constructed the house in 1945. So he became non-effective. If he become non-effective, then I shall be non-effective. I am getting it from him. But whether I am effective or non-effective, my lord, I am in person from 1980 so not, my lord. Because this is exhibit 2, my lord, the Mohim Chandra Suklapadya paying rent to the my lord, owner, Mahaprabhu Vigraha. Exhibit 2.
No, before the executing court,
Yes.
when you file your application under order 21 rule 97, what was your plea?
Now, my plea is I'm a tenant and I am a non-evictable tenant because.
You
my
are a
petition-
non-evictable tenant.
non-tenant.
Therefore, that issue was framed.
That is what same, but my question is this, my lord. So far, order 21, rule 97, whether I am a non-evictable or evictable, my lord, that is not the necessary. Board should have come to a finding first thing,
Whether
whether
you
I am
are,
a tenant, it comes since 1980 only. My lord, I am an independent right. I have an independent right to that of the ticket holder.
okay, that issue was not framed.
That is so not framed, my lord. Now, this honorable court has framed that issue, my lord. And judgment I have placed, my lord, that as per the judgment also Supreme Court, relying the earlier two judgments of the Supreme Court, that issue is only this seat, my lord. Whether I have an independent right of possession, right, or interest, title, whatever it is. That of the title.
But you could have raised this plea before the first appellate court that the issue regarding my tenancy only should have been framed.
My lord, we have argued, I shall place that judgment also. Appellate court.
Okay.
But now it is second appeal, my lord, and when issue has been framed, substantive question of law has been framed, my lord.
No, they may plea, they may make submission that no such substantial question of law
My
is
lord,
there.
that is not the question.
Therefore, I am,
When the Supreme Court has clearly said that what should be the issue before the court period, my lord. My independent right only. That is my question. Because this is not a, this is a petition under in the decree,
No,
execution of.
what I have understood from your submission, that in order 21 rule 97 petition,
Yes.
the rights of the petitioner
Right.
has to be independently
Of the decree holder.
independently assessed whether he has independent of the decree holder any right or not.
Right.
But in this case, on basis of your pleading, an issue was framed that whether the petitioner was a non-evictable tenant or not,
Right.
which was decided against you.
That is also wrongly decided because I have placed the municipal record. Municipal record shows that in a building constructed in 1945. He has taken my lord lease on 1945 and on the same year he has constructed a building. As per section 5 of the Assam Non-Agricultural Tenancy Act, my lord, if a building is constructed within 5 years of taking the lease, permanent building, then he will not be evicted. That has also not been, my lord, properly considered. Because in the municipal record, my lord, it has shown that construction, my lord, is of 1945. At second page of year of construction, 1945.
Now, in this second appeal, the first substantial question of law is whether you could establish your right,
Independent right.
possessory right, independent of the decree holder
My
or
lord.
not.
Yes.
My only query is
Yes.
whether this question
Yes.
was raised before the trial court or first appellate court or not.
My lord, I have read, my lord, these points, these are the points, my lord, I have read. That I have taken the lease from the first initially from Mohimta Suklavaidya. And thereafter I have purchased the Maliki right from their son. That I have said. Now exhibit 2 you also will see Mohimchandra Suklavaidya, he himself paid the rent to the deity, my lord, Mahapur Vigraha. Exhibit 2 pages.
Yes. Mohim Chandra Shuklavaidya paid rent to the deity.
Deity.
So he was a tenant.
But in the municipal record, my lord, the Ramanujan's name is there. So subsequently, I was paying the rent, my lord, the tax, my lord, to municipal board. That is in the name of my lord, next page, my lord. Municipal board receipts are there. Then exhibit 3, my lord, you'll also see. Exhibit 3.5. 3.5. The municipal tax, my lord. Ram Niranjan Singh Bosotkar, who is occupying. Mohim Chandra Shuklabhadra. These are all, my lord, deceased are of Mohim Chandra Shuklabhadra, my lord. Bosotkar. These documents are not considered, my lord.
Yes.
Then I am coming to exhibit 4, my lord. This is the lease deed which has been given by Mohim Chandra Shuklabhadra to the appellant, Shankar Das.
Unregistered lease deed.
Unregistered, maybe, my lord. But for portal purposes, this can be considered, my lord. Because I have got the position from this, my lord. 1980.
Yes.
This has been totally rejected, my lord. Then, my lord, next is exhibit 5, my lord, another, my lord, it was written by Manik Shuklabhadra. If your lordship see, my lord, this deed, have you got it, my lord? Your lordship? That Shankar Das, so it's a Likhitang Manik Shuklabhadra.
Exhibit 4.
Exhibit 5, my lord. No. Exhibit 4 I have placed, my lord. Exhibit 5.
Yes.
Also, my lord, your lordship will see it past Likhitang Manik Shuklabhadra, then also Jut Satta Bhumi, তদুপরি ওটা ঘেরা দি বিক্রয় নালা পত্র মিলন যেহেতু আপনি আপনার পিতা হইতে আমার পিতা হইতে বন্দোবস্ত গ্রহণ করিয়া তফসিল ভূমিতে ভাড়াটিয়া হিসাবে বন্দোবস্ত নিয়ে আসেন তাই বুক বাইন্ডিং এন্ড প্রিন্টিং এর ব্যবসা করিয়া চালিয়ে আসতে বুক বাইন্ডিং এন্ড প্রিন্টিং তফসিল ভূমিতে জমি আমার পিতা মহিমচন্দ্র শুক্লবৈদ্য রাম নিরঞ্জন সহযোগে জমিদার হইতে দুধ বন্দোবস্ত গ্রহণ করিয়া বুক দখল করিয়া আসিতেছেন তাহার মৃত্যু হইলে আমি তাহার একমাত্র উত্তরাধিকারী হিসাবে এক জমিন বর্তমান দখল হয় বর্তমানে আমার আর্থিক অনটন নিম্ন শহীদে ভূমি জুট সত্য
This deed is between
my lord
between Shankar Das and
Manik Chandra Shuklabhadra, son of Mohim Chandra Shuklabhadra. He became the owner, and that is why he sold the, my lord, property to him.
not Manik. He is some Vidhan Shuklabhadra.
No, my lord, Manik Shuklabhadra. Likhitang Manik Shuklabhadra.
Manik na Mohim.
Huh?
Mohim na Manik.
Mohim, son of Mohim. Late
Son of Manik Shuklabhadra.
Son of Mohim, my lord. Son of Mohim Shuklabhadra, the original, my lord,
Son of Manik.
Okay. No, Manik Shuklabhadra, son of Mohim Shuklabhadra.
No, which page you are reading?
My lord, this exhibit 5, my lord. Exhibit 5, you also got it, my lord.
Oh, exhibit 6.
Huh? After exhibit 4, my lord, after exhibit 4 is 2 pages.
Yes.
You also got it, my lord.
Yes. Exhibit.
Now you are also in 5. Otto Jut Satta Bhumi, 5th sentence. And Tobikoto Basogirati, বিক্রয় নালা পত্র মিলন যেহেতু আপনি আমার পিতা হইতে বন্দোবস্ত গ্রহণ করিয়া তফসিল ভূমি স্থিত হইতে ভাড়াটিয়া রূপে বন্দোবস্ত নিয়েছেন এবং তাই বুক বাইন্ডিং এন্ড প্রিন্টিং এর ব্যবস্থা করিয়া চালিয়ে আসিতেছেন বুক বাইন্ডিং এন্ড প্রিন্টিং,
তফসিল বর্ণিত ভূমি স্থিতে আমার পিতা মহিমচন্দ্র শুক্লবৈদ্য শ্রী রামনিরঞ্জন সহযোগে জমিদার হইতে এই জুত পদস্থ গ্রহণ করিয়া ভূ দখল করিয়া থাকা অবস্থায় তাহার মৃত্যু হইলে আমি তাহার একমাত্র উত্তরাধিকারী হিসাবে এই জমির মালিক সত্যবান ও দখলকার হয়। বর্তমানে আমার আর্থিক অবদান নিম্ন সৌদা ভূমি জুত সত্ত্ব তদুপরি বিহাদি মালিকা সত্ত্ব আপনার নিজে বিক্রয় করায় প্রস্তাব করিলে আপনি তাহাতে সম্মত হওয়ায় তার মূল্য 15,000 টাকা মূল্যের টাকা আপনার নিকট হইতে নগদ গ্রহণ ক্রমে সুপ্রান্ত বিক্রয় করতে সর্বপ্রকার সত্য দখল হইলাম। ইহাতে আমি আমার উত্তরাধিকারী কাহদের কোনো প্রকার আপত্তি থাকবে না। This is the salary, my lord. It may be, my lord, understand, but for the purpose of my lord, political purpose, it can be used. Then next page is my lord Bidhan Suklavodya. He is son of Manik Suklavodya. He has also written under my lord similar deed, my lord, and taking 20,000, my lord, from me. This is also under. And this holding number, my lord, this T2032 and T21, these are mentioned, my lord. The schedule, my lord, everything is mentioned. Then, my lord, your lordship may come to exhibit 7. Then the appellant himself, my lord, paid the rent to the Vigraha. After being the owner, he himself paid the rent to me. Will also got your lord? Yes. Yes, okay. Next, my lord, you'll also find the notice by the circle officer. My lord. To the appellant. You are requested to clear up your land revenue, etc. over the repayment of your existing land, that is by 10th day of February, 2008 positively, failing which necessary step will be taken.
Yes.
Then, my lord, the next activity 9. In the patta also, my lord, his name has been shown, my lord, as a tenant of Mahaprabhu Vigraha. Then, my lord, exhibit 10, my lord, that is very important, my lord. You'll also see that I am doing printing business after taking the house on rent from 1980 onwards. And this is a notice issued in 1988 by the Silchar Municipal Board. Whereas it appears that you are running printing press business without renewing the license from the municipal board as contemplated under the rule, you are hereby directed to procure the license on payment license fee in 48 hours on the receipt of the notice, failing which law will take its own course without further reference. 1988.
Your submission is that these exhibits were not considered by the executing court.
Yes.
And the first appellate court?
Has also not considered. Nothing about it. They have not considered. Then next page also, my lord, you also will find that Silchar municipality, he has paid the taxes.
Exhibit number take the. নাম্বার মিলছে না।
এখানে লেখা আছে ভাবি
না মিলে না
exhibit 10-2
এটা হবে।
that is Shankar Das deposited license fee my lord for the year 85 84 85 85 86
122 দেখো ওই জন্য মিলছে না।
আচ্ছা
Exhibit 10-2, what is this?
অন্য অন্য ও আচ্ছা। আপনি 120 থেকে 129 বলছেন। 120 থেকে
then my lord next page also my lord you'll also find my lord that 10-3 exhibit 10-3 that is from Silchar Municipal Board my lord they have received my lord the tax my lord for printing press in the year 1986 my lord for the year 1986 on 1/10/85 10 for also for 88 my lord here the vice chairman has given certificate my lord that the appellant is appellant had deposited house rent so and so license fee for printing press for the year 88-89 10-5 also there my lord Then 6 that is also similar. All are in my name. The documents clearly prove, my lord, that I am running my printing press to the place, my lord, after taking on rent from Mohim Chandra Shukla. Then, my lord, 10-10 is also important, my lord.
What is this?
This is no objection certificate from the Silchar Municipal Board in 1982. 82, my lord. 10-10, you also got it, my lord? This is 1982, my lord. Then 9 is subsequently, my lord, yes. Is also another. All the documents are there. 10-7 is there. Then I have an extra order of the CRP, my lord. Where my lord, the Sonabu court had that. We have a remedy. Minority party, we will remedy it down.
Whereby your impleadment petition was rejected.
Well, these documents really establishes that I am there since 1980, and I purchased the house and other buildings, my lord, from the son of Mohim Chandra Shukla as well as his grandson, my lord. And I am in possession. My lord, all those deeds, my lord, suppose these deed as well as the purchase deed, although not registered, my lord, for political purposes it can be used. And moreover, other municipal documents, my lord, they are very much there, which clearly proves that I am there. I have independent right to possess the property.
So your submission is that before the executing court,
Yes,
in the proceeding under Order 21, Rule 97,
yes,
it was enough for you to prove that you are a teenager.
my lord.
If that is proved, then they have to file a separate suit.
Separate suit against me, my lord. By that degree, they cannot get the. My lord, not got mass decision, my lord. There are many decisions of Supreme Court also, my lord, that for all the public event, as per section, my lord, is there. My lord, section 49 of the Registration Act, my lord.
What it says?
My lord, it says, my lord, that the effect of non-registration of documents so and so. Subsection C said, shall be received as evidence of any transaction affecting such property or conferring such power. Unless. Just my lord, I have any other judgments, my lord, no, okay. But one judgment is there, my lord, from 17 to GLT. I'm just guessing.
So that's a page, judgment.
No, legal. 17 to GLT, yes.
Page number.
568.
5-6.
What it says?
My lord, the 2 GLT, my lord.
Unregistered document may be used for collateral purpose.
My lord.
On what ground your petition was rejected? by
Now,
the-
your lordship may come to my lord, that appeal in the appeal, page 84. In this case. The discussion and this is on my lord, I am text already before your lordship. I am not going to text.
Page?
Page 84, my lord, the appellate court judgment. Appellate court judgment starts earlier, my lord. It starts at page 72 onwards, 71 onwards, 0. But I am placing 84. my lord. Discussion, decision and reason thereof.
Yes.
According to petitioner's appellant, Ram Niranjan Singh took settlement of property from Sri Mahaprabhu Video in the year 1945 and also inducted Mohimchandra Sukravarti at Tenat. Both of them constructed permanent structure on the tenanted land and became non-habitable tenants under Assam non-habitable ordinance. During the lifetime of Mohim Chakravarti, let out the suit premises to the petitioner by exhibiting a deed of Ekranama, and the petitioner continued to the scheduled premises from April 80 onwards. On the death of Mohim Chakravarti, son Mani Chakravarti made over physical possession of suit premises to petitioner in the year 1994 on receipt of valuable consideration and relinquished all his right. Subsequently, Gigant Chakravarti executed an unregistered deed in the year 1996 and relinquished his right and interest over his property. The petitioner contests that he paid annual rent and the premises to the landlord Mahaprabhu Vigraha for obtaining receipt thereof. Petitioner PW1 exhibited Ekranama, Exhibit 4, Memorandum of Handing Over Possession, Exhibit 6, and during cross-examination, PW1 replied that Exhibit 4 is a settlement house and there is no mention of land. He further replied that Exhibit 5 and 6, he purchased the jot right of the land and Maliki right of the houses on the moment of 50,000, 20,000 respectively. It admitted that both these Exhibit 5 and 6 deeds are unregistered. He has, my lord, at least
consider this. The written argument, land council of the appellant submitted exhibit 5 and 6 are not registered, but this needs to be treated as strong evidence of delivery of cash position for the suit premises in favor of the petitioner lesser. It appears to me that petitioner appellant has not filed a suit for protecting his position, but he filed a suit for declaration of tenancy right over the suit. I don't understand. I am not filed a suit. This is a case. The position of the petitioner has not been denied by the opposing party degree holder. It is only contended that petitioner appellant is allowed to stay in the suit land by Ramchandran Singh as permissive position. Thereafter, it appears to me that petitioner must prove the document on the basis of which he got that tenancy right. Admittedly, these exhibit 5 and 6 are not registered, and as such has no value in the act law. It does not confer any right to interest, so it may say to petitioner appellant. But this is wrong, madam. Exhibit 1, exhibited land revenue receipt and other documents, trade license, electricity bill notices in support of the right over the land. PDO and prosecution admitted that his name was not entered in the municipal record. The settled law that mere payment of rent does not establish the relationship of landlord-tenant. There must be some settlement given by the landlord. In light of the above, it to me that petitioner cannot adduce sufficient evidence in support of their tenancy, and as such, I find that Planet Trial Court has rightly decided the issue holding the petitioner failed to prove that they have non-applicable tenant right or suit. This is not the trial court mispointed. The other things may not seem well because already they have shown that they have the owner of it. Second issue. This is the happening project.
The executing court did not rely on exhibit 5 and exhibit 6.
And 7 also.
Holding that
Yes.
these are unregistered.
And 7 also, my lord, because this Honorable Court has framed the issue, substantive question of law 3, that substantive question of law. But the exhibit 7, which is issued by Mahaprabhu Vigraha in favor of the appellant.
That is rent receipt.
Rent receipt, my lord. So, second substantive question of law is there. Whether exhibit 7 issued on behalf of Mahaprabhu Vigraha gives sufficient significant right to the appellant on to that of the decree holder, whether decree holder can execute the decree against the appellant. Then whether land court art in law in not taking provisions of exhibit 4, which is a tenancy agreement.
About 7, nothing has been said.
Nothing has been said. My lord. They have not considered it, my lord. Both are courts. And that the third is substantive question of law, my lord, that although it is not registered, whether it can be used as a cold purpose. This is the third issue, substantive question of law, framed by this law. So my humble submission that, my lord, all the 3 substantive question of law should be decided in my favor, my lord.
How exhibit 7 helps you?
I have paid the rent to the original owner because
Therefore,
I
what it is?
since I have purchased the right of the this building, ownership of the building.
What is jot right?
Jot right, I am a tenant.
And jot right means what it means?
Jot right is a tenant.
Tenancy right.
Tenancy right. This tenancy right I purchased along with the building. So that is why I have paid the rent to the original owner. That's all. Actually, perversity is also there, my lord, here. In fact.
As because the available evidence was not
Yes,
considered.
exhibits are not considered by both the court. Both the court.
Okay.
So my humble submission, my lord, that the my petition should not have been rejected, that I failed to prove that I am non-evictable tenant. I say that I am non-evictable because my original my lord, person, tenant, Ramchandra Sikh was a non-evictable because he constructed a house in 1945. And I have come to my lord into.
Now, the question in that proceeding, instead of deciding whether you are non-evictable tenant or not,
Yes.
mere decision that whether you are tenant or not
Tenant or not an independent right to that.
would have been enough.
My lord, would have been enough. That is what I.
That is your submission.
Yes. So that is why the issue, first issue has been framed in that way.
Okay. The appellant has referred to all documents in IA 805.
IA 805.
805.
So I'll try
So
to.
you also try to.
I'll also try to refer to IA 805.
805.
Now, before I begin my submission on various aspects, Miller, one aspect I want to highlight, that is the appellant in this case appears to be confused right from the trial court as to what right he wanted to espouse. Because at one hand he said that I am non-evictable tenant. On the other hand, he said that I have a Maliki right over the property. If your lordship will kindly see his pleadings before the court below, that will be available in Miss Case 128. Huh? Miss Case 128, if your lordship will kindly pick up.
Miss Case 120.
That is what I have given, my lord.
The photocopy.
Actually, yes.
Okay.
Yes.
Which
Kindly, I just want to highlight his statements before the court, pleadings before the court, and why the eventual decision came. Are you wanting?
Same thing, my lord. I have given the.
which you are referring to?
Para 10 of their application before
Of
Para 10 of their Miss Case 128 filed before the court below.
This is Miss Case.
Yes, that the photocopy I have given.
No, no, you exhibited copy.
First,
No, I'll find it out.
I'm giving you.
This is an exhibit.
No, I'll
Of-
find
of
it out
which-
the petition. He has marked the wrong page.
Yo, great. Okay, carefully, look, party.
No, that is me. Well, this case I have given a photocopy.
You have
from
given
there,
the
10
pleading,
exhibit, the para 10.
but he is referring to pleadings.
Yes.
No, that is a pleading, my lord. Yes.
Pleading is also given.
Pleading, no, pleading in the pleading filed in Miss Case 128 before the trial court.
Yes, that is.
Yes, which para?
Para 10.
Para 10 of
This case.
the petition
Yes.
under 97.
Huh? Your lordship will kindly see it from the lower court record, otherwise it may create confusion. Because there are two IAs. Correct IAs. আপনারা আপনি 805 দিয়েছেন, আরেকটা IAS।
128.
হ্যাঁ, আমি 128 এর থেকে পড়ছি। এই যে এটা।
It may be taken up from the LCR.
Lordship may kindly take it from the LCR,
Just
otherwise it will
just
create confusion.
Just a minute.
এটা মধ্যে নাই।
Because NCR documents are very.
এটা 31 এটা মিলছে না তো।
Titles of 153.
Right. Or in the IA, your lordship will find it page 36.
Yes.
If your lordship is taking up IA 805,
Yes.
then it will come at page 36.
Page 36 para?
10.
Yes. It would be more easier to look at.
Yes. My lord, the
Because
IAs are different. That's why I thought I will show it from the lower court. Anyway,
Because if you touch more lower court records, it would get torn.
yes,
These are very old.
very well. Now, if your lordship will kindly come to para 10,
Yes.
that is his pleading that in view of the narration of facts made herein above, the petitioner has acquired a non-evictable tenancy right under Assam Non-Agricultural Urban Areas Rent Tenancy Area Tenancy Act and Maliki right over the suit premises.
Maliki means ownership.
Ownership. Maliki right over the suit premises. Has your lordship found it, my lord?
Yes.
And unless the execution pending disposal of this missed case is stayed, the petitioner will suffer irreparable loss and become rootless and roofless. Now, kindly come to his relief under paragraph 11 on the same page.
Yes.
To declare the non-evictable tenancy right of the petitioner and Maliki right of the two-storied house described in the schedule below, which is included within the decretal suit schedule premises of title suit number so-and-so, for confirmation of possession therein, holding that the decree of the title suit number so-and-so is non-executable and binding on the petitioner. For a further declaration that decree holder opposite parties number so-and-so have no right either as lessee or as owner over the land described in the schedule below, that is the decretal properties of suit number so-and-so and judgment debtor opposite party number 325 have no legal right or possession over the scheduled premises, and the alleged decree is non-est in law, as such non-executable and also not binding on the petitioner. So the right and declaration which he is seeking for are very specific, and now a different stand is taken that it has to be decided as an independent right, independent of whether he is an unevictable tenant. That is taken up for the first time in the second appeal. Now, the courts below, both the trial court as well as, the executing court as well as the appellate court, have returned findings of fact on these two aspects of the matter. And the findings of fact are that neither he could prove his tenancy right, nor could he prove his Maliki right over the suit properties.
No, his submission is, he has cited a judgment of
For collateral purpose.
No, another judgment when you were not there. 2020-16 SCC 230.
Independent right.
Independent right.
Now, if it is then it has to be a case set up by him before the trial court or before the courts below. The case set up by him before the courts below is that I am a non-evictable tenant.
Yes.
And I also have Maliki right over the suit property because of circumstances that he narrates in the application. Now, this independent tenancy is also an independent right. Non-evictable tenancy is also an independent right. It cannot be divorced from the fact situation obtaining in the case. And now it cannot be said that regardless of whether or not I am in a non-evictable or evictable tenant, trial court or the courts below ought to have decided the aspect of tenancy. That, in my respectful submission, cannot be argued now. Because the pleadings were very specific and the reliefs were also very specific. And now that the reference comes as to the exhibits, exhibit 4, your lordship will kindly see.
In original.
And I'll submit, my lord, your lordship will kindly see it from the original.
Exhibit 4.
Now, this exhibit 4 is a sale deed or a deed of conveyance. I should rather say deed of conveyance. Now, the date of execution, your lordship will kindly note, it is sometimes in the year 1980.
Exhibit 4 is a lease deed.
Yes.
Okay.
Now it is executed sometimes in the year 1980.
Yes.
1980.
Yes.
Your lordship will just see the reverse of the first page. Reverse reverse of the first page. When the stamp was issued, purchased, it is sometimes in the year 1987. And same thing happens in all other exhibits, in second page also, except the exhibit 7, and exhibit 7 I will explain. And now your lordship may kindly turn to exhibit 7. The heading, Khajna Adayer Roshid. It cannot be passed off as a rent receipt.
Khajna means?
Khajna means the revenue, land revenue. Therefore, my lord, and otherwise also, my lord, the appellate court's judgment, your lordship has seen that the appellate court has taken into account exhibit 4 and 5. Maybe there is no reference of exhibit 7. Maybe there is no reference of exhibit 7. But the finding of fact is that his independent rights, what are the independent rights? One is of the non-evictable tenancy and the other one is of Maliki right. These two rights he has not been able to establish. And that is a concurrent finding of fact by both the courts below. Hmm? Hmm.
What is the third substantial question of law formulation?
Now, the third question of law is this, my lord, whether the learned courts below are in law in not taking cognizance of exhibit 4.
Exhibit
4.
4.
Which is the tenancy agreement. Although the same was not registered, the same can be considered for collateral purposes.
And second substantial question.
Second substantial, whether exhibit 7 issued on behalf of Sri Sri Mahaprabhu Vigraha gives significant right to the appellant to that of the decree holder, and whether the decree holder can execute the decree against the appellants. Now, what significant right? His rights have to be understood, my lord, in my respectful submission. His rights have to be understood in the context of the claim that he has made. And his claim is that of non-evictable tenant and of Maliki right. And these two aspects the appellate court has very well taken into account. If I can read out the judgment of the appellate court to your lordship. And the exhibit 4, I have already highlighted to your lordship. The mismatch of the date. The purchase date and the date of execution are at a distance of 7 years, if not more.
Whether it was pointed out to trial court?
No.
Or the first appellate court?
No, it was, now I am pointing it out to your lordship. For other reasons, the trial court and appellate court did not take into account the exhibit 4. For other reasons. Because these are unregistered deeds. But the fact remains, since these were unregistered deeds, the court did not take it into account, and these aspects may not have been highlighted.
No, then what is your submission? Complete your submission.
My submission is only one.
This, if
my submission
87 and 80, what it implies?
It's a manufactured document.
Okay.
It's a manufactured document. And my submission is only one. The categorical stand and categorical plea taken by him before the trial court and first appellate court, being very pointed that he wants a declaration of his non-evictable tenancy right and his Maliki right. Two things were bounded on him. First, to establish this through a channel of evidence, and we established that who was his vendor from whom he purchased. Trial court has given a finding that Mohim Chandra Shuklavedya, from whom he says that he had purchased, that he could not establish. And there is no document to that effect. Therefore, essentially, my lord, the questions that are being asked now at the second appellate stage, my lord, I would humbly submit, these are basically questions of fact, not questions of law, and therefore cannot be gone into. Now, if I can read out my learned senior friend has read few paragraphs of the appellate court's judgment, or I'll just take your lordship to the remaining ones, starting from page 86. And before I take your lordship to 86, I'll just draw your lordship's attention to the points of determination that the honorable court had framed at page 83.
Yes.
And one aspect your lordship may also take into notice, the appellate court's judgment has recorded each and every ground that he had urged in the appeal. Right from the page 78, entire of the grounds that he had urged in the appeal have been quoted verbatim. So therefore, it cannot be said that the appellate court had committed any error in assessing the evidence and in assessing the evidence vis-a-vis the grounds that he had urged. The points for determination are whether the learned trial court rightly decided the issue that the petitioner appellant do not have non-evictable tenancy right over the suit land and maliki right and possession over the suit premises. So this part of the matter, my lord, my learned friend has already taken your lordship through. That starts from paragraph 14 at page 84 and runs up to paragraph 19. Now, the second question was whether the learned trial court has rightly decided the issue that the decree holder OP respondent has right, title and interest over the decretal property, which is the independent right. Now, kindly come to the finding at page 86. Paragraph 20. The opposite party contended that one Harichand Sarda has purchased the suit land from the original owner, that is Sri Mahaprabhu Vigraha, wide registered sale deed dated 3/1/1958, much before, my lord, this exhibit 4, 5, etc. came into existence. Ram Niranjan was a tenant under Harichand Sarda. The opposite party claimed that Harichand Sarda transferred and conveys his right and title and interest over the suit land to the opposite party wide registered deed number so-and-so dated 2006. Opposite party exhibited the certified copy of the registered sale deed number 12 of 58 as exhibit A and sale deed number so-and-so dated 29/12/2006 as exhibit C. DW2 is the official witness of the sub-registrar office and he bought the volume book to prove the deed number so-and-so. DW3 Pawan Sarda deposed that he, along with his elder brother Pankaj Sarda, jointly purchased the suit land wide registered sale deed number so-and-so from Harichand Sarda. Learned counsel for the appellant in his written argument submitted that no document, papers, evidence, rent receipts were submitted in support of acquiring lease settlement by Harichand Sarda from landlord Sri Mahaprabhu Vigraha. It is also submitted that exhibit A executed by the deity without the permission of the district judge Kachar, and as such exhibit A is not a valid document. It is also contended that exhibit B sale deed is a sham paper transaction not acted upon and no physical possession was delivered. Learned trial court in its judgment observed that the defendants have not specifically denied the execution of A and C sale deeds in their miscellaneous petition. Provision of section 68 of the Indian Evidence Act provides that it shall not be necessary to call the attesting witness in proof of execution of any document, not being a will, which has been registered in accordance with the provisions of the Indian Registration Act, unless its execution by the person by whom it purports to have been executed is specifically denied. PW1, his cross-examination replied that as per the plaintiff so-and-so, the plaintiff claimed that Harichand Sarda had purchased land on so-and-so. PW1 replied that the petitioner has not filed any suit for cancellation of the said deed. DW1 in his cross-examination, this also, your lordship, is of significance. That although it was the case set up by them, that from right from 1945, the transfer of rights and transfer of possession, etc., took place. At no point of time, this particular sale deed was challenged by them. DW1 in his cross-examination specifically replied that he has purchased Maliki right of the suit land from Harichand Sarda. He also replied that Harichand Sarda took leasehold right in the year 1958 on the strength of that registered lease deed. He has seen the lease deed. Harichand Sarda purchased Malikana from the Shebait of Mahaprabhu Vigraha in the year 1958. From the evidence on record, it appears to me that there is nothing to doubt the purchase of the suit land by Harichand Sarda from the original owner. Original owner is the deity. I find that Exhibit A sale deed has been duly proved by the opposite party. There is also no material on record to disprove the purchase of the suit land by the opposite party via registered sale deed Exhibit C. Therefore, I find that the learned trial court has rightly decided the issue, holding that the decree holder opposite party respondents have right, title, and interest over the decretal property of TS number so-and-so. The decision needs no interference by the appellate court. What is the error committed in appreciation of evidence? I heard an argument that there is also an element of perversity in the case. What is the perversity committed by the learned trial court or the learned appellate court below?
No,
These sale deeds are not in dispute. 1958. You claim to be in possession on the strength of certain documents executed on or around the year 1980, which are also not registered, unregistered deeds. And on the face of the original things that I had shown to your lordship, it appears that it's a document manufactured at a later point, at a much different point of time. Because the stamp issued in the year 1987 cannot be.
No, one leg of submission was that these documents show that he was in possession of the
Now the existence of how the documents have come into existence, my lord. On the face of this contradiction, how the documents have come into existence. And if, regardless of the fact that the trial court or the appellate court has not put light on this aspect of the matter, in the ultimate analysis of evidence, at the end of the day, what can be the conclusion? What can be a bona fide conclusion vis-a-vis these documents? Can these documents be passed off as a genuine documents so as to espouse some rights on the basis thereof? Ultimately, my lord, your lordship is examining the judgments of the trial court with the objective that whether justice has been done or not. That is the final objective of the court of law. In whatever manner the things may have been assessed, whether the byproduct of the entire exercise is justice or not. That is the ultimate query before any court of law. Now, if the trial court for X, Y, Z reasons have not given much emphasis or weight on Exhibit 4 and the subsequent documents, what is the wrong committed? In my respectful submission, my lord, the inconsistencies are so staring and glaring on the face of it.
No,
my lord.
trial court did not consider Exhibit 4 and 5 only because of the fact that they were unregistered.
Understood. I am in full agreement to this. But the question remains.
But the appellant's counsel's submission is that trial court did not discuss other documents, other exhibited documents.
No, my lord, if I have understood or if I have heard the argument properly, my lord, the emphasis from the appellant side is on 3 documents. Exhibit
7.
4, 5, and 7.
7.
Now, 4 and 5, I have highlighted to your lordship. So far as the Exhibit 7 is concerned, my lord, your lordship has seen the title of the document itself shows for what purpose it has been issued. Rent and revenue, my lord, these are two different, in my humble understanding, my lord. Rent and revenue are two different words having definite and different connotations.
And exhibit 7 is a revenue receipt.
It's a revenue receipt,
Is not rent receipt as
not a rent receipt as projected by the appellant. So therefore, since the issue, my lord, the appellate court has formulated 3 issues. And out of these 3 issues, all the issues, my lord, the first issue and second issue, I have read out to your lordship and the conclusions reached therein. So where is the element of perversity to interdict the findings of fact? Third issue was that, my lord, whether the learned trial court has rightly decided the issue that the decree of title suit number so-and-so is executable and binding on the appellant petitioner. Now, again, starting from page 87, it appears from the above discussion that, am I with your lordship?
yes.
It appears from the above discussion that petitioner appellant could not establish their tenancy over the decretal land of title suit number so-and-so. On the other hand, something is, my lord, it is illegible, is
It
proved.
is.
It is, on the other hand, it is proved that the opposite party decree holder has right, title and interest over the decretal property. So the first finding of fact is that their tenancy over the decretal land could not be proved. Therefore, there is no impediment to execute the decree which is legally obtained. Learned trial court rightly quoted the observation of the Honorable Supreme Court in Court of India in Brahmdev versus so-and-so at page 701. A conjoint reading of Order 21 rules 97, 98 and 99 and 101 projects the following picture. If a decree holder is resisted or obstructed in execution of the decree for possession, with the result that the decree for possession could not be executed in the normal manner by obtaining warrant for possession under Order 21 Rule 35, then the decree holder has to move an application under 21 Rule 97 for removal of such obstruction. And after hearing the decree holder and the obstructionist, the court can pass appropriate orders after adjudicating upon the controversy between the parties as enjoined by Order 21 Rule 97 Sub-Rule 2, read with Order 21 Rule 98. It is obvious that after such adjudication, if it is found that the resistance or obstruction was occasioned by a just cause by the judgment debtor or by some other person at his instigation or on his behalf, then such obstruction or resistance would be removed as per Order 21 Rule 98 Sub-Rule 2. And the decree holder would be permitted to be put in possession. Even in such an eventuality, the order passed would be treated as a decree under Order 21 Rule 101, and no separate suit would lie against such order, meaning thereby the only remedy would be to go to prefer an appeal before the appropriate appellate court against such deemed decree. In the light of the above observation, I therefore opine that the decree passed in title suit number so-and-so is executable and binding upon the petitioner's appellant. I find no scope for interference in the decision passed by the learned trial court on this issue. The appeal is dismissed with cost, on contest with cost. So the specific issues which have been framed by the court below, and these have been answered on an assessment of the evidence. The crux of the issue which was projected by the petitioner, who is appellant now, that he is a non-evictable tenant and he has Maliki right. Now these two issues ought to have been proved by adducing evidence, and both are contradictory. If I am a tenant, then why? How come I become a Malik? Or if I am a Malik, then why would I become a tenant of myself? Now, his Maliki right was in respect of if your lordship will again see this, Maliki right over the building, because he has constructed the building, that is his claim. So he has Maliki right over the building and non-executable tenancy rights so far as the land is concerned. That is how I understand it. That is how I understand. Otherwise, the things are irreconcilable.
Because he constructed the building.
Because he constructed the building, so he says that Maliki right over the building and non-evictable tenancy right as far as the land is concerned. Now, the construction of the building could also not be proved by him.
But when the suit was pending, they filed an application for implementing.
That was rejected by the trial court. The Honorable High Court, this Honorable Court, he came on revision, not once, twice. Once. He came on revision challenging the order of the trial court by which his application for implement was rejected. the Honorable Court rejected his, dismissed his revision petition. Now, at the time when he filed the application for impleadment, these were the only facts available with him. These were the only facts, in all probability. On the strength of these facts, he wanted to say that, look, I am a person in possession of the property. I have these sorts of right over the property. I have constructed this over the property. So I am a necessary party in this suit. If anything is going to be taken into account by the process of court concerning this property, the trial court said, no, you are not. And why it is not, probably, my lord, now I understand why it is not, maybe because these aspects were highlighted at that stage. And it was also the finding of the trial court that I am not a necessary party was also upheld by this honorable court.
Whether it was held at that time that you were not in possession, he was not in possession.
No, if your lordship
That
will kindly
is-
see the order of the honorable court.
Oh, the order 1 rule 10.
Order 1 rule 10 order probably will not be there because it is the records of the.
No, your plea somewhere I found that you are also pleading that he was never in possession.
Yes. Yes. Order 1 rule 10. Huh? No, order 1 rule 10 petition. Probably that order 1 rule 10 application will not be here because this is the records of the execution proceeding. But the judgment of the Honorable High Court is here. In this appeal also, my lord, in this. Huh?
Yeah.
This is the judgment of the Honorable Court is here. Exhibit 14. Two cases, as I said, my lord, 2 cases he had filed. 2 CRP. One is 424 and one is 425.
Why it was rejected at that time?
Well, the xeroscopy I did get there. I've given one of the evidence.
Well, the Honorable High Court was that he was
The xeroscopy
he was not to be heard in the matter. If he somehow perceives that some of his rights are affected, he no. No, High Court was the
Question not necessary party.
It was just held that he was not a necessary party. Yeah, এখানে ছিল তো এটা।
No, a submission was made that I could also observe that if
That was not.
No,
the independent right. Another spouse করতে পারবে।
the operative part, I am just reading from paragraph 7. I have heard the learned counsel for the parties, also perused the materials on record and the impugned order dated so and so. The law is settled on the point that the plaintiff is the sole architect of his plaint. It is the plaintiff who has the right to choose his own adversary against whom he seeks a relief. In the present case, there is no allegation or cause of action against the petitioners who have sought to be impleaded as defendants in the suit. Petitioners means the appellants here. The mere apprehension of the petitioners that the plaintiffs and the defendants of the suit may collusively get their suit decided, which would adversely affect the right of the petitioners, is misconceived. It is also well settled that any decree or order passed by a court would not affect a person who is not a party in the suit or the proceedings. If any collusive judgment or decree is obtained by the party to the suit, it shall have no legal effect on the rights of the present petitioners. It is not always necessary to implead a person in a suit. The impleadment is only necessary to avoid multiplicity of the suit. However, there must be such facts and circumstances to show that unless the person is impleaded in the suit or a proceeding, there is likelihood or further litigation in the same matter. The facts of the present case does not reveal that for not impleading the petitioner, there is a likelihood of further litigation in this case. This is the finding. In view of the observations and discussions made, in my considered opinion, the impugned order has been rightly passed, which needs no interference by this court. Revision petitions accordingly stand dismissed. No, সেটা নেই। This is the judgment. So therefore, my lord, my humble and respectful submission is this. The orders passed by the courts below no way warrants any interference on the supposed questions that have been framed here under the heading substantial questions of law. Because ultimately, whatever emphasis is given, those emphasis will automatically lead to findings of fact, no question of law. And therefore, this question that the first question that whether the appellant could establish his possessory rights in the premises since 1980, independent of the right of the decree holder, and thereby decree holder is not entitled to execute the decree. This does not warrant any consideration at all. Because the materials on record are only in the form of these unregistered deeds and a supposed receipt, which the appellants want to qualify as a rent receipt, which is Exhibit 7. Section 5.
Yes.
And since the plea of non-evictable tenants was raised in the petition, my lord, I would try to read out to your lordship the provision of Section 5 of Assam Non-Agricultural Urban Areas Tenancy Act.
Yes.
Now, this says protection from eviction, not.
Yes, read it. You read it.
He's supplying the book. Protect, notwithstanding anything in the contract or in any law for the time being in force, where under the terms of a contract entered into between a landlord and his tenant, whether before or after the commencement of this act, a tenant is entitled to build and has, in pursuance of such terms, actually built within the period of 5 years from the date of such contract. Your lordship has got it. Well, it will be Section 5 of Assam Non-Agricultural Urban Areas Tenancy Act.
No, you read it.
Yes.
Read slowly and.
Yes, my lord. Where under the terms of a contract entered into between a landlord and his tenant, under the terms of contract entered into between a landlord and his tenant, whether before or after the commencement of this act, a tenant is entitled to build and has, in pursuance of such terms, that is terms of the contract, has actually built within a period of 5 years from the date of such contract, a permanent structure on the land of the tenancy for residential or business purposes, or where a tenant not being so entitled to build has actually built any such structure on the land of the tenancy for any other purposes aforesaid, with the knowledge and acquiescence of the landlord. So, mere seeing will also not do. He will also have to prove the knowledge and acquiescence of the landlords as regards the carrying out construction and creating the structure. And moreover, this structure has to come in terms of the contract that he may have entered into with the landlord. The tenant shall not be ejected by the landlord from the tenancy except on the ground of non-payment of rent. Then the proviso, provided that where the tenant, having built a permanent structure within the period specified above and for any other purposes mentioned therein, renews the tenancy on expiration of the original contract, he shall always be deemed to have built such permanent structure within the period of 5 years from the date of the renewed contract. That is by a deeming provision. Provided further that a person having a right, title and interest over a permanent structure by whatever mode of acquisition he may have taken the tenancy from the landlord or the land wherein the said structure stand, shall not be ejected except on the ground of non-payment of rent. It is also further fortified that only non-payment of rent is a ground. Where a tenant has effected improvements on the land of the tenancy under the terms whereof he is not entitled to effect such improvements, the tenant shall not be ejected by the landlord from the land of the tenancy unless compensation for reasonable improvements have been paid to the tenant. So this is the ambit of section 5. So merely because saying that no, I am a non-evictable tenant will not do, it will also require proving certain additional facts, like there was a term of tenancy, and in terms of that tenancy or terms of that contract, I had built this structure with the knowledge and acquaintance of the landlord. And therefore, my lord,
Where he has failed.
where he has failed, and that's why
No,
the
no,
trial,
that is my query to you. Where he has failed in,
he has failed in proving this. That's why the finding of the trial court is that he could not prove his tenancy. Because he says that the Mahaprabhu Vigraha is the original owner, from whom Mohim Chandra Shuklavidya had taken a tenancy,
from whom he has,
come into existence. That is the projection given. And that too on the basis of these two documents, my lord, which are before your lordship now.
That one is the fabricated.
Two fabricated documents, my lord. And up to and order 21 rule 97, your lordship knows it is the possession is the essential feature.
that he is in possession, that the petitioner is in possession.
Petitioner is in possession. Now the trial court's finding are also on the aspects of his tenancy right, on the aspects of his Maliki right. These two findings are there, and these are findings of fact. And no ground has been taken, no question of law has been framed that there is a perversity. And otherwise also I have read out the judgment to your lordship how the evidence has been assessed and the findings have been recorded. So in my respectful submission, Lord, neither on the count of exhibit 4 or 5, nor in the count of exhibit 7, the judgments of the trial court and the appellate court deserve any interference. Thank you.
Now, the first thing, what my learned friend has said, that in the petition, what we have prayed. In the petition under order 21, rule 9799, we have prayed to declare non-evictable tenancy right of the petitioner and Maliki right of the two-storied house, two-storied. Because I purchased the Maliki right of that building from the son of Mohim Shuklavidya and grandson of Mohim Shuklavidya by the 2 deeds, like 6 and 7. So I have not prayed for Maliki right of the land because land belongs to the deity. So it should not be confused that these are contradictory because my tenancy right is in respect of land and Maliki right of the houses. So my prayer is, my lord, non-evictable. I have prayed on the basis of the municipal record, my lord, where it has been said, because Ramjanjan Singh was the tenant, he is admitted by the respondent also. He respondent admitted. So in 45, he has taken the rent, and in 45, he has constructed a building. From the exhibit 1, it has been proved, my lord. That is why I said I am non-evictable. Because he has made permanent construction in 1945 itself. Secondly, my lord, my learned friend is saying, my lord, it's a khajana. Khajana, my lord, is land revenue. My lord, I could not understand, my lord. In Kachhar, my lord, always it said the Porja Rangso, but that piece, my lord. They say Porja. And khajna means the land, my lord, the rent. If you also see exhibit 2 also same. Mohim Shuklavidya, same thing. Khajna Aday Rasid, Porja Rangso. Masik Khajna Nirik, so and so. They have said.
What is the?
Khajna means, my lord, they always say, my lord, it is Khajna in Kachhar.
For rent, what is the vernacular equivalent?
My lord, rent.
Bangla, my lord, we call bhara.
Bhara.
Bhara means, my lord,
only in respect of house, my lord, they say. Normally, in respect of land, my lord, the is all the, my lord, the deities, my lord, they issue visiting this, my lord. And Proja means, my lord, they say, because they are tenants. Proja means tenant, they say Proja. My lord. Similarly, my receipt is same, Proja also. That exhibit 7. Proja also.
Okay. What this means, Projaranko?
Proja means tenant. They say Proja, my lord, tenant. In Qatar, always the receipt printed receipts are in Ismail. My learned pen knows it.
Not tenant.
Proja.
Proja is the land original owner from whom the land has been taken.
They are actually riots.
Riot.
What if,
In Assam, it is called riot.
riot, maybe my lord, same thing. I am a riot there.
Well, there is a difference in riot and tenant.
Same thing, my lord.
Because it
I
is
don't
an urban areas property.
And below the
And concept is
immovable,
not enough.
My lord, in the Satyans, my lord, the tenants.
No,
always-
one question to Mr. Dutta.
yes, my lord.
What it implies, Exhibit 7, it gives no, it has no impact at all.
My submission is that, my lord, he has only paid whoever is the, my lord, the payer.
Shankar Das.
Yes, he
the
has only
appellant,
paid the revenue, land revenue.
without being in possession.
Maybe. Maybe without being in possession, because my lord, one thing your lordship will kindly appreciate. He is asking a Maliki right over a property, which is an immovable property. And immovable, in respect of immovable property, my lord, registration is compulsory. So without there being any proof or any evidence of registration, my lord, how can you claim that you have constructed this house? So why I said, my lord, the things are little bit contradictory, because if I say that I am non-occupancy tenant and therefore I have become, if I am non-evictable tenant, because becoming non-evictable tenant will imply two things. Not only I have come into possession of the land with
I also constructed.
I have also constructed, not only that, I have constructed with the knowledge and acquaintance of the owner. And that is in terms of tenancy, the contract of tenancy. Now, where is the evidence in respect of these? Now, if I have come on tenancy, my lord, and I have constructed with the house, then how do I claim a Maliki right over it? If I say Maliki right, my lord, then there has to be a conveyance, transfer of property from one hand to the other through a process of registration. That's why I said, my lord, that these things do not go hand in hand together.
Anything else?
Well, yes.
One,
of the
one query.
islands,
Before you submit one query,
yes.
you said that even if it is unregistered deed,
My lord.
it can be used for collateral.
My lord.
What collateral?
Yes.
The position I put it, my lord, as it can.
That you were in possession.
My lord, I am in possession. And moreover,
Without having,
all the
without
documents-
being in possession also, you can execute an unregistered deed.
Yeah, well, here even verbal deed also, my lord, the lease are given. Verbal also. Not necessary, my lord, that verbally also, my lord, the tenants are paying the rent.
But
May-
suppose you are in possession without any lawful right.
My lord, my first thing is this, here, because the exhibit 4, 5, 6, my lord, 5, 6, I have purchased the houses. My lord, along with jot right. 5, 6, I have purchased the jot right as well as houses. Jot right means I have the tenancy right. My lord. Tenancy right, I have purchased.
And that is why, my lord, I have given the rent to the original owner. Okay. And moreover, the municipal records and other documents, my lord, circle officer notice, my lord, regarding payment of revenue, as well as other documents, clearly proves that I am there since 1980.
Yes, on this you have not made any submission. On other,
No, my submission is only, my lord, I am trying to make,
With the-
keeping in focus the questions of law that is,
substantial question.
questions
The
of law
first
that have been.
substantial question of law.
Now, the questions of law that have been framed are,
The
my lord,
first one.
first one is that whether appellant could establish his possessory rights in the premises
For that
since
reason-
1980.
Yes, then in that
Now,
respect.
my lord, this, I remember, if I remember correctly, the first day when I appeared in this matter, the question fell from your lordship, whether this question at all qualifies as a substantial question of law. Because it is entirely on the fact. If I could establish my possessory rights in the premises since 1980, independent of the right of the decree holder. You say it is essentially a question of fact. How can it be regarded as a question of law? Well, if I remember correctly, my lord, that was a question posed by your lordship. And that too on the basis of two documents, exhibit 4 and 5. And we were just discussing, my lord. If I say that I purchased Jot right and I also constructed the building, then how do I become non-evictable tenant? If I am a tenant, then why would I purchase? If I am a non-evictable tenant, then why would I purchase the Jot right of the land? Jot right of the land, my lord, my senior friend said that it is the tenancy right. Now, if I am a non-evictable tenant, then why would I purchase a tenancy right? And that too through these two documents executed in the year 1980, but the issue of the documents are in the year 1987.
Okay. Yes.
My lord, Jot right and Maliki right of the building I have changed from the son of Mohim Chuklabardo as well as grandson of him. Not from exhibit 5 and 6. Secondly, my lord, the municipal records and other documents clearly show that I am there in possession of the building and I am running a printing press. Yeah. And Ramjanjan Singh was the original tenant, my lord, that was admitted by him. And Ramjanjan Singh and Shuklabaddo, Mohim Shuklabaddo both constructed houses. And in the municipal record also shows that Mohim Shuklabaddo was the occupier. And ultimately he rented me out. Then his son and grandson sold me out the houses. And that is why I have paid the rent to the original owner. And so far, High Court order is concerned, it has been especially said that if any collusive judgment or decree obtained by a party, the suit itself have no effect on the right of the present petitioner. My right will not be affected. That was discussed, that not done, but my right will not be affected because I have the right under order 97.
No, but that right you have to establish in 97 petition.
Yes.
Under order 21 rule 97.
That is what I have established, my lord. That is what I have established. I am saying that I am a tenant since 1980 in respect of land and building. Now, in 94 and other, my lord, I have purchased the buildings as well as the tenancy right. After purchasing tenancy right, I have paid to the owner. The rent. Even circle officer has issued a notice to me, my lord, that for paying of the land revenue. That your lordship has seen, my lord, exhibit 8 in 1988. It is of 2008, my lord.
And these were not considered.
Not considered. These
But-
documents, my lord,
But no issue on the question of perversity was framed.
no, first issue contains everything, my lord. Whether I could probe my independent right. My independent right, my lord, that flows from the my evidence and documents. My independent right of possession. That separate issue need not be framed, my lord. Because my right, they are independent right, my. And printing press I am running, that nobody can deny, my lord. And I am in the possession, my lord. This house. Still I am in.
And even, my lord, as per section 100, my lord, substantial question of law can be framed at the time of hearing. My lord, and here also, my lord, I think.
Then let us frame it if it is
My lord.
necessary.
My lord, right. And moreover, my lord, in the
Then you have to plead that for, at least you have to make a submission that
There is
this-
perversity.
there is perversity, therefore this issue is
my lord,
repeated.
and in appellate court below, my lord, I had submitted that the land could not have been sold without a uh, permission from the district judge, because
No, no.
after all,
We will not go into those
Right.
issues.
Yeah,
Your,
judgment
your,
factor.
your submission is that other documents,
Yes.
these municipal documents,
Yes.
which shows that the appellant is running a printing press
Yes.
in the, those
These-
were not considered.
These were in the issue number 1 itself, my lord. Whether I could prove, could establish possessory right in the existing land.
No, but for, to go into that issue, we have to go into question of facts.
No, one
Question
these
of
documents-
facts, we can go
these
only
documents have to be
if
considered,
there
my
is
lord.
a question of perversity. Yes.
No, these documents have to be considered, my lord. So for that purpose, because these documents will not be relevant for the purpose of non-habitual tenancy. These are only for the purpose of possession.
Then let us frame an additional issue.
Yes,
My lord, I,
Can-
what I would submit, my lord, subject to
yes,
your lordship.
it can be additional issue can be framed, my lord, because the section 100 says that issue can be framed at any point of time.
Well, his appeal was exhaustive. In the appeal filed before the appellate court, first appellate court, there was no question of perversity asked. My lord, I can read all the, well, it is in the appellate court's judgment itself. All the grounds have been reproduced. All the documents have been referred to. Now, in the appellate court's judgment also, your lordship will find that nowhere in the grounds he has urged that the trial court's finding is perverse. Nowhere in the grounds he has urged that the decree has been obtained collusively. My lord, to get the benefit of the observation of this honorable court in the civil division petition, which has been shown to your lordship, that there is an observation that a collusive decree will not be binding. My lord, for that matter, there has to be a finding of court that the decree is collusive. In the appeal memo, my lord, there is not even a whisper that the decree has been obtained collusively. There is not even a whisper that there is a perversity in the assessment of the evidence. How in the second appellate stage, my lord, it can be framed now?
No, only thing I
No,
am
it can be
submitting.
framed, it
Perversity
can be formulated,
My lord,
but you
Subsection-
can argue that it is not there.
yes,
Yes.
subsection
No,
4.
no, that's why, my lord, I am indicating
But
that
we have not yet formulated.
My lord, section 100, subsection 4, where the High Court is satisfied that a substantial question of law involved in case, it shall formulate that question.
my lord,
Now,
lordship can
now,
formulate, but it will be an
perversity,
unnecessary exercise.
perversity
We'll
question-
formulate it and hear you after for 15 minutes more.
Yes, yes, my lord, this can be framed. The perversity, my lord, that can be framed.
Then we are framing an issue that
Yes, ma'am.
whether the first appellate, the trial court as well as first appellate court judgment is perverse in not considering
Yes,
other exhibits apart from exhibit 4 and 5.
yes,
On that, you have already made your submission. You have to reply.
yes.
Exhibit 7 considered one.
Exhibit 7 is, I mean, in a way, tangential way touches that. But my reply will be very simple. The,
Exhibit 4, exhibit 7. Substantial.
these are already, exhibit 4 and 7 is already taken into account in the substantial questions of law. Now,
Yes, other exhibits. that
he is
you-
referring to other exhibits.
Yes.
Now, if other exhibits are also taken to be account, my lord, then the question of perversity has to be raised by him somewhere, sometime before coming to the court of second appeal.
In the first appellate stage.
First appellate stage also, there is no ground of perversity. Not even a ground that the decree has been obtained collusively. Your lordship will, lord, if your lordship requires me, lord, I can read out the entire judgment, my lord. The grounds have been extensively quoted there. Merely, my lord, for the sake of saying that it is perverse, we will not do. There has to be, and what are the other documents? My lord, the other documents have to be looked into. Other documents except other than the exhibit 4, 7, and 5. The question, your lordship is formulating the question of perversity vis-a-vis the other
And
documents.
the other exhibits.
Vis-a-vis the other documents. Now, what are the other documents, my lord? Your lordship will kindly see the observation of the discussion of the trial court in the miss case 129. No, it is 128, no?
No, miss case 128.
Dada, no, we take to them now. Judgment of the trial court
At page,
my lord, I am just referring to it. It is, since the miss cases are different. Better. Page 58, it starts from page 58. Page 58. That is number 4. Page 4 to 4 as well. And internal page 61, your lordship may kindly see. Page 61,
yes.
paragraph 2. I'll read from paragraph first paragraph. There is no document to show that the settlement took place in the year 1945.
Yes.
There is no evidence on record to show that Ram Niranjan Singh and Mohim Chandra Suklavidya constructed the permanent structures within 5 years of their tenancy. There is also no evidence to show that prior permission for construction of permanent structure was obtained from the concerned authorities by Ram Niranjan Singh and Mohim Chandra Suklavidya. There is also no evidence to show that Ram Niranjan relinquished his right over the suit land and the scheduled land was settled with Mohim Chandra Suklavidya. The petitioner produced the rent receipts showing payment of rent by Ram Niranjan Singh to the landlord and exhibited the same as exhibit 2, 2.1, 2 and 2.2. The petitioner exhibited the municipality tax receipt as exhibit 3, 3.1 to 3.31 showing payment of tax in respect of the holding by Ram Niranjan Singh. In respect of holding by Ram Niranjan Singh, PW1 contended that during the lifetime of Mohim Chandra Suklavidya, he let out the scheduled premises to him by executing a deed of Ekrarnama dated 15/10/1980, that is the exhibit 4. And he was in continuous possession of the said house. The Ekrarnama has been exhibited as exhibit 4. The petitioner failed to prove exhibit 4 document. Now, this is a finding of fact. The exhibits, the other exhibits that are being referred, that was also taken into account by the learned court below. On the death of Mohim Chandra Suklavidya, his son Manik Suklavidya made over physical possession of the scheduled premises to the petitioner in the year 1994 on receipt of valuable consideration and relinquished all his right. The petitioner exhibited the said memorandum as exhibit 5 with signatures of so-and-so and so-and-so, as exhibit 5 to Morilal Sahani C. and so-and-so. Bidhan Suklavidya exhibited an unregistered deed in the year 1996 and relinquished his right, title and interest over the scheduled property. The petitioner exhibited the said memorandum as exhibit 6. So exhibit 2, 3, 4, 5, 6, everything have been taken note of by the learned trial court. The petitioner exhibited the said memorandum as PW2 in his cross-examination deposed that he was not a witness to any of the settlement between Manik or Mohim Suklavidya and Shankar Das. He also do not know about any settlement between Mohim and Mahaprabhu Akhra. He also deposed that he was not a witness to any deed of purchase of settlement by Shankar Das from Manik Suklavidya in 1995. The petitioner exhibited rent receipts issued by Binod Ranjan Chakraborty, Shebite of landlord, showing payment of rent by him as exhibit 7. So this also comes into reference. It appears that the petitioner claimed to be a tenant under landlord Sri Mahaprabhu Vigraha, but the said landlord deity has not been made a party in the present case. Moreover, the rent receipts exhibited by the petitioner has not been proved. Mere payment of rent does not necessarily establish relationship of landlord and tenant and may only prove permissive occupation not amounting to any right or title to possession. Section 54 of Transfer of Property Act provides that transfer of tangible immovable property of the value of rupees 100 and upwards can be made only by a registered instrument. Well, that is what I just submitted sometimes back. Section 110 of the Indian Evidence Act provides that when the question whether any person is owner of anything of which he is not shown to be in possession, the burden of proving that he is not the owner is on the person who affirms that he is not the owner. It appears that the OPs exhibited the certified copy of registered sale deed number so and so, showing purchase of the scheduled land along with other lands from Sri Sri Mahaprabhu Vigraha as Exhibit A. Now, this 1955 deed of say purchase, my lord, that is not disputed. Even the appellate court has recorded this fact while deciding point number 1. And the municipal receipts, my lord, how does that municipal receipt proves that he is a tenant in respect of these premises? Municipal receipts have a bearing so far as carrying out some business or occupation is concerned.
This case number 1828 is the case registered on his 97.
Yes, yes. Now, thereafter, it appears that OPs exhibited the certified copy of the registered sale deed number so and so, dated 3/1/1958. OP means me, showing purchase of scheduled land along with other lands from Sri Sri Mahaprabhu Vigraha as Exhibit A. The Jamabandi of the suit patta has been exhibited as Exhibit B, showing mutation of name of Sri Sri Mahaprabhu Vigraha, Harichand Sarda, and the certified sale deed, registered sale deed number so and so dated 2006 has been exhibited as Exhibit C in the support of their title over the scheduled property and has been able to discharge their burden. The petitioners thus failed to prove their non-evictable tenancy right over the suit land, over the land, Maliki right and possession over the decretal premises. The issue is as such decided in the negative. So this was the threadbare consideration of their case. And thereafter in the appeal also, your lordship will not find any order of, any ground of perversity. So now at this stage, my lord, in my respectful submission, it cannot be said that it is the decisions have been rendered in perverse assessment of the evidence. Well, the other case also same. Well, I am not reading the two judgments because these are the second case is also same. Same judgment. And issue number 3, whether the decree holder OP number 1 and 2 has right title interest over the decretal property. There, my lord, my right title and interest has been discussed.
The second case, that is
129.
129, the Sita Devi.
Yes.
That is in respect of some other property. The property must be.
Yes. Adjacent property. Adjacent property.
But separate suits were filed.
Separate suits were filed. And he filed implement application in both the suits. Both the suits, implement was rejected. He came before this honorable court on revision.
And in that case, the exhibited documents are different.
Numberings are different, but otherwise same.
4, 5.
Numbers are different.
Numbers are different, but the documents are same. Huh?
My lord,
Numbers
what
are
my learned friend is saying, we have taken a ground, my lord, especially for that learned court will majorly fail to shift and appreciate the evidence adduced by the parties. And most of it in the past order dismissing of this. This is the ground, my lord. At page 17 of the judgment also it is there. In the judgment they have put.
RSA 121.
That is in RSA 121. The first one.
My lord, page 79. Paragraph 4.
So some facts are different in both the cases.
Slightly, my lord, different. Slight. Other earlier documents are same.
Documents are same. It has been
almost
numbered differently.
But subsequent documents are in the.
Cannot be disposed of by a common judgment, first of all, because
No.
separate judgments.
But
should be different.
I feel, my lord, that that may be taken up, my lord, after.
On common judgment.
No.
Same question of law was framed.
Some question of law is framed, but
Same question.
with the exhibits, you have to, your lordship has to.
Only the number of exhibits will be different.
No,
Only number of. Same question.
And
because we will be only revolving around substantial question of law.
Yes, my lord. Constitutional question law and the next, your lordship, my lord, that the perversity, my lord.
The lordship can decide it. I think, my lord, substantial question of law also has been framed, same substantial question.
Yes.
So the lordship can decide it
And
together.
the exhibit number is also same.
No,
except
exhibit number is slightly different.
Now
After
seven is mentioned, 7 and 4.
After 7,
After 7, other numbers are
Up
different.
to 7 and 4, it is same.
Same.
Okay.
My lord, here, no, my lord, something else different, my lord. Exhibit 4 is different, my lord, here. They have said, my lord, that husband of the petitioner, my lord, he paid the rent to the owner. I shall give it, my lord, separately.
Separate sheet, in a separate sheet.
Separate sheet, I shall give it, my lord.
Lord, that we can do. We can indicate the separate exhibit
Yes,
numbers.
that would be helpful.
Easier.
My lord.
Otherwise it will be difficult.
Yes.
Yes, I shall give it.
A gist of,
You can copy to them, my lord.
in both the appeals,
Yes.
gist of your argument and the exhibit briefcase.
My lord.
Yes.
Okay, heard Mr. G. N. Sahewala, Lalit Senior Counsel, assisted by Miss.
Oh, no, it's not law, my lord.
When can you give the gist of your argument? Within a week?
Yes, yes, sure, my lord.
End of this week.
Yes.
By Monday, by Monday.
By Monday.
স্যার আপনি আগে দিবেন তারপর আমরা
Sure, totally they are okay. Why, same time, already argued.
We always, like, he is a formidable opponent. We always try to take care of his presence.
Item number 14 and 15. 14 and 15. Heard Mr. G. N. Sahewala, learned senior counsel, assisted by Miss S. Todi, learned counsel for the appellant. Also heard Mr. S. Dutta, learned senior counsel, assisted by Mr. S. K. Ghosh, learned counsel for the respondents. Respondent number 1. And other respondents are there? Oh, okay, respondent number 1. The hearing is concluded in both the appeals.
Sorry, my
law
lord,
may be
respondent
Oh,
number
oh,
one,
yes.
not 1, 1 to 6.
1 to 6,
One.
stop. Before during the course of hearing, it was felt that an additional substantial question of law is required to be framed in this appeal. Accordingly, after hearing learned counsel for both the sides and after considering the materials on record, following additional substantial question of law is hereby formulated in addition to already formulated 3 substantial question of law. Dash, whether the judgment of executing court,
Judgment of both the courts.
judgments of executing court as well as first appellate
Yes.
court. First appellate court are perverse to the extent that it did not consider the materials on record, including the exhibited documents except exhibit 4, 5, and 7 for arriving at its finding. So the hearing is concluded. Learned counsel for both the sides are requested to submit a gist of their respective argument, brief gist of their respective argument to this court within a week from today. The judgment is reserved.
Obliged.
আরো কি আছে? Item 5. Item 5, we have heard, I think.
Yes, my lord.
at-
That my lord abatement and
Okay. No, I have made my notes. Whether a request was made to you for submitting any written gist,
no,
brief 1 page,
no, lordship had not.
you may submit, both of you,
Okay.
2 pages.
My submission, I already concluded my submission.
No, not oral submission.
Written.
Today I am not reserving the judgment.
Okay.
You submit a
Written notes.
written gist of your
Argument.
argument, which you have already made
Yes, please.
within a week.
My lord.
Or when can you
Yeah,
can you
within a week,
within a week?
within a week by this week we'll finalize and write it.
Okay. Heard Mr. J. Ahmed, learned counsel for the appellant. Also heard Mr. A. Das, learned counsel for the respondent. You are appearing for all respondents?
Only for one, my lord.
Respondent,
On respondent one.
respondent number 1. The hearing is concluded. Learned counsel for both the parties are requested to submit a written gist of their argument within brief. Don't make it bulky. 2 pages, 2 or 3 pages.
Or else I'll just make these bullet points like
Yes,
so that your lordship only goes through the particular line and gets done.
Within a week from date of this order, the judgment is reserved.
That'll be realistic, that'll be very good. But do we need
You
to
file it,
in
no, you give it to the court master. Court master.
the.
In earlier case also, Mr. Ghosh, you can also give it to the court master.
Yes.
Don't file it in the registry.
Registry, that is.
To give it to the court.